Visayas at Mindanao. Ito po ang ika-6 na araw ng paglilitis, katarungan para sa taong bayan, ang special coverage ng kauna-unahang paglilitis laban sa isang punong maestrado ng Korte Suprema. Ako po si Cathy San Gabriel.
Ako naman po si Gio Tingson mula po sa Senado sa tulong ng pinag-isang lakas ng PTV, IBC, Philippine Information Agency, Radyo ng Bayan, Philippine News Agency at 15 radyo at cable networks. Narito po tayo mula sa Senado.
At mapapanood din po nyo ang aming coverage sa aming website via live streaming www.angpaglilitis.ph. At Gio, maraming expectations sa araw na ito. Unang-una ay ngayong araw nakatakdang isumite ng prosekusyon ng kanilang memorandum at yun nga ay naisagawa na nila kaninang alas 10:08 ng umaga.
Nakita nga natin, no, at ang daming usapin kahapon, especially when Senator Miriam Santiago entered the court. Pinag-usapan din nila, ano ba yung mga bagay tulad ng quasi-judicial body ba talaga or quasi-political? Ito po yung mga aspeto na matitignan natin at masasagot sa nagaganap na caucus ngayon ng Senado. At
kahapon din sa ating panayam kay Senadora Santiago ay kanyang inilahad din na kailangang sundin ang rules of court pagdating sa ebidensya dahil ito ay subok na. At maaaring mas maging liberal naman ang Senado pagdating sa proceedings.
So makikita natin na at least yung sa naganap na mga usapan, iba't iba yung panig na ilalabas, especially doon sa nasamiting memorandum ng prosecution, kung saan sasabihin nga nila na dapat ibuuhin at ang admission ng Article 2.4 at 2.3.
At kahapon nga, Gio, walang mga dokumento o mga witnesses na naipresenta ang prosekusyon, ngunit mahalaga rin ang araw kahapon, ang Day 5 ng paglilitis, dahil dito po ay natalakay nga, gaya ng aming nasabi, itong mga mahalaga, mga fundamental issues tungkol dito sa impeachment trial. At narito po ang recap ng mga highlights kahapon, panoorin po natin.
Hindi natuloy ang pagpresenta ng testigo at ebidensya ng prosekusyon sa ika-5 araw ng paglilitis. Sa halip mga kwestiyon patungkol sa mga patakaran sa pagpresenta ng ebidensya at pagdedesisyon ng presiding officer ang nanaig. Naisa na ng prosecution team na ipresenta si BIR Commissioner Kim Henares at ang income tax return ni Chief Justice Renato Corona. Sinimulan ang paglilitis ng mosyon mula kay Senator George Gringo Honasan na ipaliwanag sa simula pa lamang kung tumatalima ang impeachment court sa presumption of innocence gaya ng batayan sa mga ordinaryong korte. Pareho namang sumang-ay ng prosekusyon at depensa na tumatalima sila na inosente ang isang tao hanggang napatunayan ito'y nagkasala. Nagulat ang prosekusyon nang biglang hilingin ni Senadora Miriam Defensor Santiago ang kabuuang bilang ng mga testigo at ebidensya na magkabilang panig para hindi na matagalan pa ang proseso.
To be able to shorten the proceedings, let me ask both counsel, for the prosecution and for the defense, how many witnesses do you intend to present, including rebuttal and surrebuttal? Counsel for the prosecution.
Your Honors, for today we will present at least 7 witnesses.
For today?
Yes.
But for the totality of the trial period, how many approximately do you intend to present? And don't shake your head at me. You should have known. You should even have a trial brief.
Yes, Your Honors.
Oh, so what? What is the answer? How many witnesses do you intend to present?
Well,
You don't even have...
I have to ask, Your Honors,
No,
the
that is not
teams
acceptable. No.
in charge
You come
with
to
the
court
articles.
prepared. You do not waste the time of this court. Tell us how many witnesses you should have had.
Can you give me a few minutes so that I can
Yes,
consult with the team
I
leaders
will
each
request the
article,
majority
Your
leader
Honors?
to take up this request sometime during the appropriate period of these proceedings. And defense counsel, please, how many witnesses?
We are prepared, Your Honor, to present 15 witnesses, Your Honor.
In all, in total?
Yes, Your Honor. Yes, Your Honor.
Ayon sa prosecution panel, bagamat handang-handa sila sa paglilitis, nagulat sila sa kahilingan ni Santiago.
At saka nakakagulat yung tanong ni Senator Miriam. But if we were asked how many witnesses, hindi mo masasabi dahil may 8 kaming grounds. If we were given up to tomorrow to prepare for it, for that number, we would have been able to say it.
Inaprubahan naman ng mosyon ni Senator George Miriam Defensor Santiago na isumiti na kaagad ng prosekusyon at depensa ang kabuuang listahan ng kanilang mga testigo at ebidensya para di na maantala pa ang paglilitis. Ayon din kay Senadora Santiago, dapat pagbotohan na lang kung ano ang gagamiting batayan sa ebidensya. Dahil sa kakaibang uri ng paglilitis, nais si Senadora Miriam na gamitin ang overwhelming preponderance of evidence bilang batayan. Nais ng prosekusyon na gamiting batayan ng substantial evidence habang nais naman ng depensa na gamitin ang proof beyond reasonable doubt.
Yung kasing criminal case, proof beyond reasonable doubt. Pag criminal case ang ituturing dito, talagang walang kaduda-duda na may kasalanan na wala kang pagdududa. Yung civil proceedings, yung preponderance, ibig sabihin, mas nakakarami yung ebidensya mo. In terms of quantity and quality, mas malaki yung ebidensya mo kaysa doon sa kabila.
Sa isang mosyon, hiniling naman ng depensa na huwag munang hayaan ng prosekusyon na magpresenta ng ebidensya hanggat hindi pa nadidesisyonan ang kwestiyon patungkol sa alegasyon ng nakaw na yaman at hindi pagsasama ng ilang ari-arian sa salin ni Chief Justice Renato Corona. Pinagtanggol ng prosekusyon ng naturang dalawang akusasyon na nakasaad sa explanation ng Article 2. Hiniling naman ni Presiding Officer Juan Ponce Enrile sa prosekusyon na ipaliwanag ang mga akusasyon nila sa Article 2 para maintindihan ng publiko ang nasa saad dito. Ayon sa head ng prosecution team na si Neil Tupas, ultimate facts o katotohanan ang inilatag nila dito at supisyente na naiintindihan ng akusado ang mga akusasyon laban sa kanya. Sagot naman ni Justice Serafin Cuevas ang depensa, base lamang sa sabi-sabi o chismis ang mga aligasyon kung kaya't hindi ito maaring tanggapin bilang ebidensya. Sinabi naman ni Senador Santiago para hindi magsuspecha ang mga tao na may itinatagong ebidensya gaya ng naganap noong impeachment trial ni dating Pangulong Joseph Estrada nang hindi hayaang buksan ang second envelope, huwag pigilan ang paglabas ng ebidensya para maalis ang pag-aalinlangan tungkol dito. Umapela naman si Senator Alan Peter Cayetano na hayaang lumabas ang ebidensya.
Pag nasuppress po natin yung ebidensya dito, bayan ang talo. Bakit po? Sa criminal case po, meron double jeopardy. Dito po, kung technicality na sinasabi ng Constitution at American authorities na hindi dapat, all they have to do is file this again next year. And we'll go through it again. So kung ma-convict o ma-acquit, dapat on the merits with all evidence being presented here. So that's my appeal.
Hiniling naman ng prosekusyon sa presiding officer na i-relax ang pagpapatupad sa rules of evidence at procedure. Napakarami daw kasing pagtutol ng depensa kung kaya't napakabagal ng pag-usad ng kaso.
Ang naging pakiusap natin is pabayaan nating pagdesisyonan yung usapin ng admission on ill-gotten. Very confident kami dyan. Pero in the meantime, na hindi yan nadidesisyonan pa, ay bayaan kami magpresenta ng aming mga testigo. Para hindi na antala ang kaso.
At naging napakalinaw ng paliwanag ng ating Senate President o presiding officer. Sabi niya nga, gusto niyo flexibility, gusto niyo liberal, sabihin niyo sa akin ang panuntunan. Lagi kayo nagsasalita ng liberality, pero ituro niyo sa akin ang panuntunan.
Ayon kay Law Dean Amado Valdez, magiging malaki ang epekto sa paglilitis ng magiging desisyon ng korte patungkol sa kung magiging mas liberal ang aplikasyon ng mga rules of procedure.
Ang Article 2 ba tungkol lang sa failure to make a public statement of assets and liabilities o kasama na ba rito yung tinatawag na ill-gotten wealth? Sabi ng prosecution, kasama na dyan dahil yung Article 2, kailangan basahin mo yung Article 2 to point A, to point B, etc. Kailangan kunin mo sa kabuuan. So sinasabi naman yan, hindi. Kailangan nakalagay doon sa caption, which is hard to swallow sapagkat kung i-concentrate mo lang doon sa caption, doon sa heading, saan mo dadalhin ngayon yung iba, di tatapon mo yun. Kasama yun doon. Kaya ang only test dyan, kung sino ang tama o hindi, yung kung binasa mo ba ito, alam ba ng isang Chief Justice kung ano yung demanda laban sa kanya? Para alam niya kung ano ang depensa niya.
Niliwanag naman ni Enrile na base sa kanyang karanasan, naangkop ang mga reglamento na nasa saad sa rules of court sa nagaganap na paglilitis. Subalit kung may suhestyon ng alimang panig para mas maging patas at makatarungan ang proseso, bukas naman siya dito.
Na itong paglilitis na ito ay hindi ito lamang ang mangyayari sa ating bansa. Kaya ako ginagawa ito para sa ganun ay merong magiging tularan ng mga susunod na hahawak ng kapangyarihan dito. Para sa ganun ay may direksyon at order ang ating sistema. Kaya ginagawa ko po yung kaya kong magagawa upang malinis at transparent itong ginagawa natin para ang ating taong bayan ay magkaroon ng paniniwala na tayo ay talagang marangal, makatwiran, makatarungan at tapat ng mga hukom na inutusan ng ating mga taong bayan sa kanilang konstitusyon upang magbigay ng hatol ng hustisya sa sino man na nasasakdal sa atin.
Pinagtanggol naman ng ilang center judges ang kakayahan at pagiging patas ni Enrile bilang presiding officer.
So far, very fair. And maganda yung conduct niya ng impeachment court. Nobody can accuse him or accuse the Senate that we're favoring one side. So it's the credit goes to the Senate President.
Iniutos naman ni Presiding Officer Enrile ang prosekusyon na isumiti bukas ng umaga ang kanilang memorandum patungkol sa mga kwestiyon sa Article 2. Bukas, pagdidesisyonan ng korte ang kwestiyon tungkol sa kasapatan ng alegasyon ng prosekusyon sa nakaw na yaman at hindi pagsasama sa salin ng ilang ari-arian ni Corona. Pagkatapos ito ay magsisimula muli ang prosekusyon sa pagpresenta ng iba pang testigo at ebidensya.
At sa puntong ito, alamin po natin ang kaganapan sa paligid ng Senado. Naroon ang aming kasamang si Zarina Lusuegro. Zarina?
Ika-6 na araw ng impeachment case laban kay Supreme Court Chief Justice Renato Corona ay nananatiling payapa at tahimik dito sa labas ng Senado, habang ilan namang media agency kasama ng inyong lingkod ay nananatiling nakalerto. Kanina nga eksaktong alas 10 ng umaga ay nagsumite na ang prosecution team ng kanilang memorandum kaugnay nga sa hinihingi ng impeachment court na listahan ng kanilang ebidensya at testigo kaugnay sa Article 2 patungkol sa Statement of Liabilities and Net Worth o SALN ni CJ Corona. Ngayon naman sigurado na ang pagsalang sa witness stand ni BIR Commissioner Kim Jacinto Henares bilang testigo ng prosecution kung saan ay kasalukuyan ng nasa loob ng Senado. Bitbit nito ang income tax return ni CJ Corona mula 1992 hanggang 2010. Samantala, bagamat nagkaroon ng maliit na aberya kahapon sa paglilitis dahilan kung bakit natapos ito ng maaga, sigurado naman ngayon tutuloy na o sesentro na sa Article 2 ang pagdinig ngayong araw. At yan muna ang pinakauling detalye dito sa labas ng Senado. Back to studio with Gio and Kathy.
Maraming salamat, Zarina Lusuegro at Gio. Kasama natin ang mga spokespersons mula sa prosekusyon at sa depensa.
Pakilala na natin si Congressman Sunny Angara at si Attorney Karen Jimeno.
Good afternoon.
Hi.
Magandang hapon, Gio and Kathy.
Congressman Angara, kanina po ay naisumite ng prosekusyon itong memorandum na binigyan nga ng deadline ni Senadora Santiago o ng Senado para ngayong umaga. Ano po ang nalalaman dito?
Well, yung nilalaman po nun yung opposition namin dun sa motion nila na tanggalin po yung tagong yaman dun sa Article 2. Ang sabi po namin ay yun ay bahagi ng aming aligasyon na may tagong yaman si CJ dahil hindi po makatotohanan yung kanyang idineklara sa kanyang salin. At meron tayong ebidensya doon, meron tayong mga titulo ng kanyang ari-arian. So, sa tingin po namin, ay bahagi po yon, integral po yon. So, hindi dapat tanggalin po yon. Tapos, yung hiningi po ni Congressman Tupas kahapon, na huwag sana maging masyadong stricto yung korte sapagkat mismong si Chief Justice Corona sa kanyang desisyon sa Francisco case, kanyang opinion, sabi niya, ang impeachment, hindi civil case, hindi criminal case. So dapat hindi tayo maging strict to there. Yung natatanging layunin niya ay tanggalin po yung public officer. So wala pong penalty, wala pong deprivation ng life, liberty, or property, hindi po siya minumulta, hindi po siya pinaparusahan.
Pero pag sinabi niya, Congressman Sani, na be more liberal, what does this mean precisely?
Yung maging liberal dun sa pagtanggap po ng ebidensya. At maging liberal din pangalawa dun sa quantum of evidence, yung tinatawag nating kabuuan na ebidensya na kinakailangan para mahatulan ang isang nasasaktan.
Attorney Jimeno, nasabi na po ni Congressman Angara yung nilalaman ng kanilang memorandum. Ano pong reaksyon ng depensa dito sa mga nakasaad sa kanilang memorandum?
Siguro sasabihin ko lang dun sa sinabi niyang opinion ni Chief Justice Corona na dapat pagka-impeachment maging liberal tayo at hindi masyadong technical. Siguro sang-ayon kami doon, pero kailangan importante rin dito, wag nating kalimutan yung mga karapatan na nasa saligang batas. Ito'y mas mataas pa sa impeachment proceedings dahil ito nga ang mismong saligang batas ang nagbuo sa impeachment court. Kaya hindi natin pwedeng sabihin na mabubura yung mga karapatan sa saligang batas porque nasa impeachment proceedings tayo. At ito yung pinaglalaban ng defense team para kay Chief Justice Corona. Kasi nung umpisa pa lang, nung nag-file sila ng impeachment complaint, yung Article 2, hindi nila linagay doon ng maayos. Nakasama naman yung tagong yaman sa kanilang mga akusasyon. Kung kasama talaga ito, dapat doon pa lang sa caption sinama nila. Ang nakalagay lang doon ngayon, failure to publicly disclose the SALN. At yung paglahad nila doon sa ill-gotten wealth ay isa lamang suspecha. At ito'y lumalabag din dun sa isang requirement na kailangan may personal knowledge ka. Kung ikay nag-aakusa, hindi dapat nagsususpecha ka lang. Kung papaharapin mo yung tao sa isang korte, kailangan meron kang basihan dito bago mo pa i-file yung complaint. Kaya para sa amin, hindi lang ito technical. Ito'y napupunta doon sa substantive na mga karapatan. Ibig sabihin, hindi lang ito dahil sa mga technicalities nga ng law, kundi yung karapatan niya mismo nasa saligang batas na hindi natin pwedeng burahin. Ito yung naapektuhan.
Kahapon po ay hiningan kayo ni Senadora Santiago ng listahan ng mga witnesses and mga pieces of evidence. Ready na po ba ang prosekusyon na isumite ito?
I think binigyan sila ng ilang araw para ibigay yung pre-trial, yung tinatawag na pre-trial brief kung saan nakalagay yung numero ng mga testigo. At magko-comply naman kami.
Attorney Jimeno, itong paghingi ng listahan, dahil nga walang naging pre-trial dito sa Paglilitis, ito po ba ay pabor o laban sa inyo, sa depensa?
Pabor sa amin ito dahil gusto rin namin mabilis matapos itong impeachment proceedings. At yung nangyayari nga dati, kahit yung pagtalakay doon sa articles of impeachment, hindi namin malaman kung ano yung unahin dahil walang paunang sabi sa amin at bigla na lang nung unang araw na akala namin Article 1 yung tatalakayin, biglang sinabi nilang Article 2. So ngayon, inaasahan namin na mas magiging maayos yung takbo ng impeachment proceedings pagkalinabas na itong listahan ng kanilang mga testigo at yung mga ilalabas na rin nilang mga ebidensya.
Sa tingin niyo ba, attorney, mas mabilis yung proseso ng impeachment kung nagkaroon ng pre-trial? Or as this goes along, madali lang din na ma-appreciate ng mga tao yung mga kaganapan?
Siguro mas bumilis kung dati nagkaroon ng pre-trial. Pero syempre, rinerespeto namin yung desisyon ng impeachment court. At siguro yung nagkaroon ng delay dati kung anong article yung i-hear nung kinailangan isuspinde yung hearing dahil nga nagkagulo kung Article 1 or 2 ba, yun siguro kahit walang pre-trial hearing, may iwasan yun kung nasabihan ng mas maaga yung defense, pati yung mga senator judges na uunahin ng Article 2.
Congressman Angara, kahapon po ay may ilang mga senador kaming nakapanayam dito sa aming programa at kaisa po sila sa pagsasabi na dapat po ay yung mga issues na raise kahapon sa trial ay masettle bago po ipagpatuloy itong paglilitis. Sa inyo pong palagay?
Well, siguro yung ibang issue ay kailangan ma-settle muna, lalong-lalo na yung sa Article 2. Pero palagay ko, kasi last week, hindi pa naman settled yung Article 2, pero pinayagan na kami magpresenta ng ebidensya. So yung mga, hindi naman nagkakaiba masyado yung mga witness namin, register of deeds din, mga anti-testigo, tapos mga dokumento tulad ng titulo. Kung bakit pinayagan last week at hindi pinapayagan this week, yun ang medyo nako-confuse kami ng konti. Kung bakit inuna na rin yung sa Article 2. Sa amin, sunod lang kami sa korte.
And ano po ang aasahan namin ng publiko sa day 6 po ng trial today?
Well, yun nga, siguro nagsubmit na kami ng sagot dun sa memorandum at uunahin yung desisyon doon. I think nagko-focus ngayon yung mga senador pag-uusapan yon. At handa kami presenta yung mga Register of Deeds, yung mga ehekutibo ng mga property companies, at andyan din si BIR Commissioner Kim Henares.
So mga ilang witnesses pa po ang nalalabi para dito sa second article of impeachment?
I think at least 5 ho. At least 5 GFI.
Sa defense po, ano pong makikita natin at least for today? What are we expecting?
Sa ngayon, syempre, dahil sila yung magpipresenta ng ebidensya, mag-o-object lang siguro kami kung merong basihan sa rules of evidence at kung ito'y hindi nga consistent dun sa mga alegasyon nila. Kaya sa amin, napaka-importante na sana magdesisyon na kung ano ba yung sakop ng Article 2 para rin maiwasan na yung mga either technicalities at patuloy na paglabag nga dun sa due process rights ni Chief Justice.
Napag-usapan mo yung konsepto nga ng evidence. Ano ba yung ine-expect ng defense, siguro pati ng prosecution, na quantum of evidence na magiging basihan ng impeachment ng Chief Justice?
Hanggang sa ngayon, ito yung isang tanong na inaantay na namin kung ano yung magiging desisyon nila. Kasi nga, ibang-iba, malayo yung pananaw namin. Sa amin kasi, proof beyond reasonable doubt.
At sa prosecution naman ay substantial.
Sa amin, substantial or clear and convincing evidence.
Ano po ba yung ibig sabihin nun?
Yun nga maganda sana ipaliwanag natin sa ating kababayan. Yung proof beyond reasonable doubt, yan po ay ginagamit sa isang criminal proceeding. Pagka may pumatay o kaya may ninakaw, yung siguro kung i-translate natin roughly ay walang kaduda-dudang ebidensya na nagawa yung krimen. Yung substantial evidence, yung clear and convincing, ay yung kabuuan ng ebidensya na maiisip na pwedeng isupport yung isang konklusyon. Kumbaga, kung nakita mo, parang tama nga yan. Na kahit may konting duda, kung naniniwala ka naman na tama, nakabase sa ebidensya, yun ay isusuportahan sa isang hatol. So palagay ko yun ang nakikita natin. At klaro naman po pag binasa po natin yung records nung may akda ng Constitution, yung records of the Constitutional Commission, klarong-klaro po doon nung pinagdidibatihan po nila Commissioner Ricardo Romulo, Commissioner Regalado Mambong, tinanong, what quantum of evidence, ano yung kabuuan ng ebidensya na i-apply po natin dito sa impeachment proceeding? At sabi niya, definitely it's not proof beyond reasonable doubt. It is not a criminal proceeding.
Pero anong interpretation natin sa sinabi ni Senator Miriam kahapon na overwhelming preponderance of evidence? Ano yung diferensya niya doon sa mga interpretation na
yun ay bandang gitna po yun. Bandang gitna po yun.
Ito yung hindi pa natin siguro may karapatan siyang sabihin, gumawa ng sarili nilang quantum of evidence kasi nga sui generis o walang katulad ang impeachment proceedings para itong criminal case, pwede rin itong parang civil case, pero ang nakikita kasi natin ngayon sa mga batas at sa mga dating kaso, either proof beyond reasonable doubt para sa mga criminal cases, substantial evidence para sa civil cases, and clear and convincing evidence sa administrative case. So,
yung overwhelming preponderance of evidence nakuha sa Estados Unidos po yan. Ang nag-teorya po yan si Professor Charles Black ng Yale University. So palagay ko yun ang naging basehan ni Senator Miriam.
Attorney Jimeno, bakit po proof beyond reasonable doubt ang gusto nyong maging batayan ng pagdidesisyon ng mga senator judges sa conviction or acquittal ni Chief Justice?
Kung napakinggan nyo kahapon si Justice Cuevas, ito yung pinaliwanag niya na yung penalty na ibibigay sa impeachment ay parang perpetual absolute disqualification. Ang ibig sabihin nito, hindi na siya pwedeng humawak ng kahit anong pwesto sa gobyerno. At yung ito yung kapareho ng isang penalty na mabibigay sa iyo sa revised penal code. Ito yung batas natin para sa mga krimen. At doon nga, pagka kunwari binigyan ka ng perpetual absolute disqualification, fine lang ang minumulta sa iyo. Sa impeachment proceedings, mafo-forfeit o tatanggalin lahat ng pensyon mo. So, lahat ng pinaghirapan mo sa bawat taon na nagserbisyo ka sa gobyerno, mawawala ito. Kaya sabi niya, kung ganun kalala yung ibibigay sa yung penalty, dapat pareho rin sa revised penal code yung kailangan mong patunayan na ebidensya. At yung isa pa, dun sa House Rules for Impeachment, nakalagay doon, may isang provision doon na nakalagay, the rules of criminal procedure shall apply. So ito, kung nandoon pa lang to sa pagsisimula ng impeachment na nasa pag-iimbestiga pa lang, ay rules of criminal procedure na yung ina-apply nila, lalo na siguro doon sa court na maglilitis doon sa kaso.
Baka pwedeng sagutin po yun. Well, unang-una, yung sa House proceeding, supplementary po yung application. Pag wala nang ibang i-apply na batas, tsaka lang mag-a-apply yung rules on criminal procedure. Tapos pangalawa, yung sinasabi ni Attorney Jimeno na criminal ang pagtatanggal sa posisyon ni Chief Justice at mawawala yung kanyang pensyon at siya hindi na makakapagpanilbihan sa gobyerno. Yan din po ang ipinapataw na parusa sa isang judge na nadidismiss administratively ng Supreme Court. At ano po yung nature ng proceedings sa administrative proceedings? Administrative po siya. At ano po yung quantum of evidence? It's only substantial evidence po. So kung nambabae po ang isang judge, kung nagloko po, kung hindi niya dineklara yung kanyang salin, pwede po siyang patawan ng tatanggalin sa serbisyo, mawawala po yung kanyang pensyon, at hindi na po siya makakapanilbihan sa gobyerno. Yan po ay exactly the same po as an impeachment proceeding. So hindi yata tama na may double standard tayo na mas stricto tayo sa Supreme Court Justice pero sa judge naging administratibo lang, mababa lang po ang evidence natin at ang quantum of evidence.
Kahapon rin po ay merong isang punto na ni-raise itong si Senadora Santiago. Pardon me, hindi po ako abogado. Pero yung interpretasyon ko po dito ay parang sinasabi niya, yung nakalagay po sa konstitusyon ay ang maximum na maaaring penalty dito sa mai-impeach na public official ay yung pagkakatanggal sa pwesto. Pero wala pong nakasaad doon na minimum. Para sa inyo po, pwede po ba na kunwari ang sa tingin nila ay guilty pero pwede nilang patawan ng suspension lang? Ganun po ba yung ibig sabihin nun?
Sa akin, pwede. Kasi pag binasa natin ang Senate Rules of Impeachment, merong isang provision doon nakalagay that the impeachment court can issue their own rules and decisions and render judgment at nakalagay rin doon na may karapatan silang i-enforce ito. So para sa akin, walang limitasyon kung anong klaseng penalty ang ibibigay nila sa impeachment.
Kayo po,
Congressman. Parang suportado rin yun ng lingwahe ng ating saligang batas sapagkat ang nakalagay doon ay yung parusa ay hindi lalampas sa pagtanggal sa pwesto. So, kung hindi lalampas, kung mas konti naman, pwede siguro. So, meron tayong range, may acquittal, may conviction. Sa gitna, siguro may discretion ang Senado kung anong ipapataw.
Will the prosecution settle for that?
Well, wala naman tayong choice. Sa totoo lang, Gio, we leave it to the senators. Pero mahirap rin kasi kung parang napakabigat nung sakdal tapos parang sasabihin mo censure or reprimand lang. Parang dapat siguro akma yung parusa dun sa kasalanan.
Congressman Angara, meron po akong babasahin na excerpt from the memorandum that you submitted a while ago. Corona claims that paragraphs 2.3 and 2.4 of the complaint are conjectural and speculative and do not amount to a concrete statement of fact that might require a denial. Corona ignores the reality that these proceedings have long left the realm of pleadings and allegations and have now reached the stage of presentation of proof. Ano pong ibig sabihin itong nakalagay na ito?
Well, ang ibig sabihin yan, yung mga objection na nire-raise nila, yung mga technicalidad, dapat dun sa sagot pa lang niya, sinabi niya. Kasi parang winave na niya. Yung pag winave mo, ay sinabi mo ng parang na-join na yung tinatawag sa batas yan, yung joinder of issues eh. Parang pag sumagot ka, na-meet mo na yung issue. At ang sagot po ni Chief Justice Corona nung sinabi namin na meron siyang tagong yaman, ang sagot niya, hindi po ako magnanakaw, hindi po totoo yan. So ngayon, parang hindi na siya pwedeng bumalik dun sa puntos na sasabihin niya. Hindi niya naman sinabi na magnanakaw ako eh. Parang yun ang, parang nare-rewind po yung ating proceedings. Kumbaga, ang sinasabi namin, inamin mo na yan sa inyong answer eh. Kumbaga, alam mo, ibig sabihin nun, alam mo yung akusasyon. Tapos ngayon, sinasabi nila, hindi nila alam yung akusasyon. At bahagi yan ng kanilang due process o yung tamang kaparaanan ng batas. So parang dalawa, magkataliwas yung dalawang sinasabi, kumbaga.
So ang ibig niyo po sabihin, dahil sinagot niya, ay tinatanggap niya po itong issue na ito?
Opo, sinagot niya. Siya nag-speech po siya sa Supreme Court. Sabi niya, I'm not a thief, di ba? Unlike some of those accusing me. So at least inaamin niya na may akusasyon na magnanakaw siya, di ba? Ganun lang yun eh.
Sagot po ng depensa.
Para sa amin, hindi nga sapat yung kanilang alegasyon at kung yung pinakinggan nyo rin kahapon si Justice Cueva, sinabi niya nga, doon naman nasa klarong-klaro rin sa answer na ang sinabi niya, yung allegation na yan ay speculative and conjectural. Kaya nga sabi niya, hindi na nga namin dapat papatulan pa eh. Pero, syempre, to avoid yung technicality rin na kasi pag hindi mo rin sinagot ang isang allegation sa complaint, kahit na isang paragraph pa yan, meron din kasing technicality na deemed admitted. So, yun din yung iniiwasan dyan. Kahit na hindi klaro sa amin, ano ba yung binibintang nyo? Anong ill-gotten wealth? Wala namang detalye kung ano nakalagay dyan. At unang-una, hindi yan base sa personal knowledge na kinakailangan sa ating batas. Gayunpaman, kailangan i-deny, kahit general din yung denial, kailangan gawin yan para hindi sabihin, inadmit nyo naman by your silence. So, yun lang, dahil nga may mga technicalities involved, iniiwasan din namin na mag-apply yun.
Ang daming magaganap sa araw na to, especially that maraming technicalidad din na napag-uusapan. Ng umaga, habang papunta kami dito, ang daming kabataang nakapila sa Senado. At dala-dala nila, pag tingnan nyo sa screens natin, makita natin yung mga kabataan, dala-dala IDs, eager and are willing to listen, to learn. Anong tingin yung impact nito sa karamihan, lalo sa kabataan na nanonood ngayon? Attorney?
Palagay ko, gusto rin nilang maintindihan kung ano yung nangyayari dito sa impeachment proceedings at bakit yung ating punong maestrado ay nandito ngayon. Para sa amin, napaka-importante na makita nila na ito ginagawa ng maayos at tapat, makatarungan at transparent nga. Kasi katulad ng sinabi kahapon ni Senador Villar, hindi lang ito maapektuhan tayo. Ito ang unang beses sa pagkakataon ng kabanata ng bansa natin na ang punong maestrado ay ini-impeach. Ngayon, kung tayo ang magiging halimbawa ng kung paano dapat isagawa ang impeachment proceedings, anong klaseng halimbawa ang gusto natin ibigay doon sa mga susunod na henerasyon? Dapat gawin natin ito ng maayos, na sang-ayon sa batas, at hindi yung parang gagawin nga natin na trial by publicity o maghuhusga tayo bago pa ito matapos. So dapat talaga na tama-tama na may partisipasyon ng mga mamamayan.
Maganda yung sinabi ni Karen, talagang yung ginagawa po natin dito, nagpapakita tayo ng halimbawa para sa darating na henerasyon. Sa akin, makikita ay on trial din po yung mga institusyon ng ating bansa. Makikita kung mabilisan ba ang hustisya dito, kung nakabase ba siya sa sustansya o sa tamang argumento o nakabase lang siya sa maliliit na bagay, teknikalidad ng litigasyon. So palagay ko yan ang mga issue na nakikita at nagmamasid ang mga kabataan at saka ibang kababayan natin.
At kaugnay niyan po, ay napansin namin kahapon, no? Kasi over the weekend, there was a clamor to hold the hearings in Filipino. And napansin po namin na karamihan sa mga senator judges ay nagpipilipino na. Kayo po, sa prosekusyon, pabor po ba kayo dito?
Ay, pabor na pabor po. Yun lang medyo may konting mga salita na mahirap po i-translate. So siguro kailangan may konting, yung transition po from English to Filipino, medyo siguro gradual po, hindi biglaan. Otherwise, baka magkamali po tayo sa ating mga sinasabi.
Pabor din kami kasi lalo na kung makakatulong to sa pag-intindi nga ng mga taong bayan. Yun, at naniniwala rin ako sa sinabi ni Sonny na meron din talagang mga salitang napakahirap i-translate. Kasi kahit kami, Pinoy kami, nagsasalita kami Tagalog, pero nung nag-aral kami sa law school, in English yan. Pati batas natin nakasulat in English. So hindi mo basta-basta rin ma-translate kasi minsan wala rin naman talagang kapareho sa Tagalog.
At least yung questioning po siguro, no, yung pagtatanong sa mga witnesses, pwede po yun.
Opo. Okay. Maraming salamat po mula sa prosecution, sa defense. We're very excited for today at nakita nyo, ang daming nanonood sa atin at ngayon, pila-pila pa rin yung mga kabataan sa labas, lumalabas sa reports. Maraming salamat. Thank you for your time.
Salamat.
At ngayon naman po, alamin natin ang pulso ng taong bayan tungkol sa kaganap na paglilitis. Panoorin po natin ito.
Kahit sa totoo lang, yun talagang dapat impeach talaga.
Saka para sa totality sa lahat, siguro magandang matapos makita kung may guilty ba siya or hindi. Kasi at least magkakaroon ng closure.
Sana maging ehemplo kung talagang may kasalanan, maparusahan. Isimula na ng pagbabago yun.
At yan nga po, napanood natin yung mga kuro-kuro, no, at mga views ng taong bayan tungkol sa nagaganap na paglilitis, ang kauna-unahang impeachment trial po laban sa punong mahestado ng Korte Suprema. At Gia, nakakatuwa na nakita natin dun sa ating video kanina itong mga kabataan, no, I think mga college students ito.
Iba-iba actually. Nung nakapila pa ako doon sa labas, bago makapasok doon sa security, basan sila ng mga student IDs. So ito may from Kalayaan College, may from University of the Philippines, at nakikita sila, pag makita mo sa screens ngayon, handang-handa yung mga kabataan. I think they're very eager to learn and to understand how our democratic institutions are working.
At yun nga, no, ito rin ang hinihikayat ng ating mga senator judges at maging ng ilang mga political analysts. Alamin naman natin ngayon ang mga kuro-kuro sa Twitter at Facebook accounts natin. Ito sa Twitter mula kay Clarissa Santos, I don't know why I can't stop watching Chief Justice Corona's impeachment trial. I've been watching the videos on YouTube for hours now. Mabuti yan, Clarissa.
Tingnan naman natin ang susunod. Mula kay Gabriel Liwanag, hindi na dapat pahabain pa ang impeachment trial ni Corona. Dapat tapusin na, madami pang trabaho. So gusto nila ng business as usual, no?
Ito naman sa Twitter pa rin mula kay LJ Lacuna, napakatagal naman ng usad ng impeachment trial ni Corona. Ano ba ang balak nyo? Yan,
Iba yung mga tanong. Ang susunod naman.
Sa Twitter, sa katotohanan mangibabaw sa paggamit ng Pilipino ng husgado kay CJ Corona, salamat at pinagbigyan ang sambayan intindi at makalahok sa mga pinag-uusapan. Yan, no? Ito nga yung kanina tinanong ko at pabor din na kapwa ang depensa at ang prosekusyon na gamitin ang wikang Pilipino para nga naman mas maintindihan ng taong bayan. Kasi ito yung kanilang ginagawa, no? Hinihikayat nila ang taong bayan na makinig, manood, makilahok, no? Dito sa sinasagawang paglilitis, ngunit paano nga naman sila makikilahok at manunood kung hindi nila naiintindihan? So
marami nga, diba, nag-i-interview ng mga tao at talagang tinanong, hindi natin alam kung, kasi parang biglaan na ang prosecution, ang defense at ang mga senator judges nananagalog. So hindi na baka napag-usapan ba to or talagang nakikinig, klaro yung pagkinig sa pulso ng bayan na gustong maintindihan to ng madlang Pilipino.
At Gio, ngayon naman kasama natin ang ilan sa ating mga panauhin. Sila yung mga regular panelists natin dito sa Ang Paglilitis. Si Attorney Kaloy Ocampo, ang ating legal expert. Magandang hapon po, Attorney.
Magandang hapon, Kathy. Kasama rin natin mula sa ALSP, or Association of Law Students of the Philippines, si Dino Austria.
Magandang hapon.
Attorney Ocampo, nabasa niyo na po part of the memorandum that was submitted by the prosecution. Ano po ang masasabi niyo dun sa mga inilahad nilang mahalagang argumento dito?
Ang prosecution? Anyway, ang pinaka-importanting punto ng prosecution is waive na ang mga objections ng depensa. Kasi they did not object before the answer. There was an order given by the presiding officer in Enrile on the second day, I think, and they agreed. And then may tinatawag na rules, sa rules of court, omnibus motion rule. If you are attacking, and that's what the defense was doing, if you're attacking a pleading or an order, you have to state all your objections in that motion. Sa umpisa pa lang po. Sa umpisa pa lang. Sa opposition, I think the pleading that they are referring to is the motion for preliminary hearing. The reason that they wanted, the reason why they were attacking the complaint is because of the verification. Sa verification lang, walang mention about Article 2. Yan ang punto ng prosecution. And sa aking palagay, it's a strong argument. So let's see later kung ano magiging desisyon ng impeachment court.
Kahapon po ay humingi si Senadora Miriam Defensor Santiago nitong listahan nitong mga witnesses and documents mula sa magkabilang panig. Paano po makakaapekto itong paghingi niya nitong mga listahan na to sa pag-usad ng paglilitis?
Definitely makakatulong. Ito yung repercussion siguro na walang pre-trial. Kung nagkaroon ng pre-trial, then they would have already enumerated kung ilan witnesses ang gagamitin, ano yung mga documents na ipipresent. But since they did not have a pre-trial, there's no choice but to have a piecemeal. Parang piecemeal pre-trial ito, which is better than nothing.
Attorney Kaloy, dito po sa mga listahan, kunwari po nagsamuti na both sides nitong listahan ng kanilang mga witnesses, ngunit along the way, meron silang gustong idagdag. Pwede pa po ba itong ma-admit dito sa paglilitis?
Pwede. Basta reasonable request upon motion, I think it's not a problem. Usually, sa mga pre-trial brief na ginagamit ng abogado, they make a reservation. So, something like, we will present 5 witnesses, but reserve the right to present additional witnesses as the need may arise. So I think that's what they will do in this case.
So same case siya pati sa mga dokumento kasi dalawa yung tanong ni Senator Miriam kahapon ilang dokumento ang isasumite bilang ebidensya at ilang witness ang gusto yung ipasok sa witness stand.
Pwede mag-insert ng reservation in both cases. So documents and witnesses. So if they don't do that, that's a big mistake. So let's see what they will file.
So ang pagpayag naman po ay depende rin sa desisyon nito nga mga senator judges, ganun po ba?
Yes, if they will be submitting additional, they will have to check if it's really relevant. If not needed, corroborative evidence, meaning dagdag lang na ebidensya, you already prove your point and still you want to submit 5 more witnesses, malamang hindi na papayag ang impeachment court.
Man bilang isang law student na subaybayan mo na nakakaisang linggo na mahigit itong paglilitis, anong masasabi mo sa usad ng takbo nitong paglilitis? Mabagal ba siya? Mabilis?
Tama lang para sa amin dahil we're very happy to see that the Senate has considerably relaxed the rules just to be able to facilitate the impeachment. And we also recognize as students of the law that hindi naman pwedeng sobrang madalain nitong proseso na ito because it has serious repercussions. That's why we are stand naman namin ay pro-process. So talagang gusto namin makita na yung process na to ay magawa sa tamang paraan. So for us, it's not proceeding slow.
So masasabi mo, Dino, na yung paghiling ni Chief Prosecutor Neil Tupas kahapon na maging mas liberal ay reasonable dito sa impeachment trial?
I believe that he asked the presiding officer to be more liberal in accepting evidence. Yes, we agree with that because hindi naman ito isang criminal proceeding. So and the Senate has made their own rules on how to be able to carry out this impeachment properly as they see fit. So we leave it to the discretion of the presiding officer.
Dino, yung mga manonood, they can't help but judge the performance of both the prosecution and the defense. Ikaw at yung iyong mga kaibigan na mga nag-aaral ng abogasya, anong kuro-kuro ninyo tungkol dito sa mga performance na tinatawag nitong depensa at prosecution?
Well, we have to admit that we're somewhat impressed with how the defense has handled the case thus far. So, pero we also recognize that this is a very difficult process, diba? So, and there is really no precedent that they can rely upon. So, yeah, we look forward to seeing this, and we're very excited to see it as it unfolds.
So ano kaya yung mga paraan para mas mabilis na, para makasunod ang taong bayan dito sa pag-intindi ng impeachment process? Correct, kanina may nakita ang daming kabataan na nanonood ngayon. May anong mga mainam or madadaling paraan para mas malagom yung karanasan ng impeachment o yung pagnood at pagmasid sa impeachment process? Dino?
I think, this, for example, what we're doing right now, talking about it, will help a lot. And the fact that you have invited our organization, ang Association of Law Students of the Philippines, to be able to talk about it is already, for us, one of the steps to help properly inform the public about what is really happening in the country.
Attorney Caloy, kahapon po ay dinefine ni Senadora Santiago itong nature nitong impeachment trial at sinabi niya ito ay isang quasi-judicial at quasi-political trial, no? Process, kumbaga. Ano pong masasabi niyo dito? Ano po bang ibig sabihin nito pag sinabing quasi-judicial, quasi-political?
In a way, tama rin si Senator Santiago. Quasi, it's like a court, quasi-administrative, political. Yes, it's very much political, so it has features of political. Quasi a lot of things. It's also within the powers of the Senate to decide anong quantum of evidence ang gagamit. Up to them. In her personal view, she said overwhelming preponderance of evidence. So, preponderance of evidence, yan ang ginagamit sa civil cases. Proof beyond a reasonable doubt, yan ang ginagamit sa criminal. So, in that case, I think somewhere in between. But others are saying this should be more like an administrative case. And the proof is substantial evidence, lower than preponderance of evidence. Because he's the chief magistrate, highest justice in the land. If the basis for removing a mere judge is substantial evidence, why should you make it harder to remove the chief magistrate? Shouldn't it be the other way around? Because we expect him to be the best. He must have high ethical standards, highest among all of them in the judiciary. So that's also a strong argument. And if I'm not mistaken, the Senate will go into a caucus to decide what will be the quantum of evidence.
At isa rin po sa pag-mimitingan nitong Senado, yung pagre-relax nga ng rules. Sa inyo pong palagay, ano po ba yung dapat maging pag-handle ng Senado dito pagdating sa pag-admit ng evidence and yun nga, yung rules on pleadings, no? Ito pa hindi pa rin nasa-settle.
Sa aking palagay, technical rules should not overshadow the main objective. And the main objective is ascertaining or getting the truth. I am a fan of the lawyers who can display their brilliance in court or in this impeachment court. But that's not the most important thing. The most important thing is that the evidence is presented in such a way that we can find out whether or not the Chief Justice is fit for the job, period. And if the technicalities will overshadow the main objective, then I think this process will be a failure.
Karaniwan bang hinihingi sa husgado, sa judge, ang pagiging mas liberal sa proceedings in a court normally?
Hindi kailangan eh. Because in a court, in a regular court, they're expected to use the rules of court. And in this case, the rules of court only apply suppletorily. Pag walang provision na applicable sa Senate rules, then you go to the rules of court. But I think I've gone over the Senate rules and they're well drafted. So it's really up to the senators to decide how much they should use in the Senate rules and how much they should borrow from the rules of court.
You think they should have been more particular in writing those rules down? Which should they use from the rules of court? You think it should have been included in the rules of impeachment?
Para sa akin, okay na eh. Because it gives the impeachment court sufficient discretion to maneuver, to decide. And you saw in many cases, the presiding officer has to be flexible when certain questions arise. So hindi pwedeng masyadong stricto ang Senate rules. I think it's in the construction and interpretation of the rules that counts a lot. Now,
may gusto yata sabihin si Dino tungkol dun sa tanong ko.
No. I agree with what Attorney Calo has said that it applies suppletorily naman talaga. So, enough lang yun na, tama lang yun na hindi talaga sinabi kung anong particular rules sa civil procedure ang kailangan na mag-apply dahil as the rules stand, it's supposed to be sufficient, but just in case there is a deficiency, that's where the civil procedures will apply.
Pero parang hindi ba sinasabi ng mga tao may weighing daw dito ng substantial and procedural due process? Parang sa kaso ng impeachment, ano ba ang mananaig sa dalawa?
In my opinion, it's not a choice between the two. You have to comply with both. Substantial meaning may basehan for the removal. And procedural, notice and hearing. Ito na yung notice and hearing
Ito yung
at the level of the Senate. I think there was some confusion earlier. Deprivation of due process. Well, I don't agree because
ito yung inilahad ni Justice Cuevas noong ikalawang araw yata nito.
The hearing really precisely is at the level of the Senate, not at the House. Meron akong pahabol on your other question. Itong impeachment process, hindi para lamang sa mga abogado. This is for everybody. If the people have to ask sinong lamang, sinong nananalo, then that means they don't appreciate what's going on. So I think that should be the cue in determining how technical they should be in receiving the evidence.
At nakita po natin sa ating video kanina ay ilang minuto na lang po mag-uumpisa na naman itong ika-6 na araw ng paglilitis ng impeachment trial laban kay Chief Justice Renato Corona. Naghahanda na po, nandito na ang ilan sa mga miyembro ng prosecution team. 8 minuto na lang po ay inaasahan na nating mag-uumpisa itong ika-6 na araw ng impeachment trial. Nakita po natin kanina ay nandun na itong mga photographers at ilang mga miyembro ng media. At kanina nga, Gio, ay kagaya ng iyong napansin, no, nandito rin puno na halos itong gallery. 175 lang po kada araw ang pwedeng papasukin dito sa loob ng session hall ng Senado.
So kahit kompleto na nakita natin, nakapasok na yata ang mga uusig para sa Article 2, no, si Congressman P.D. Barzaga, kasabay niya ang mga private prosecutors, sina Attorney Mario Bautista. Naghahanda na rin po yata sila. So nakita natin, ang sabi nga ng mga kabataan, gusto nila makita in person itong mga icons na sinasabi, icons of justice, icons of those who are running the judiciary. Kasi malaking misteryo since before na ano ba talagang nangyayari sa loob ng hudikatura. So parang sabi nila, the impeachment process sheds light on what's happening in the judiciary. And dito nakita man daming kabataan niya, ang ganda nung maganda ba tong pagpasok o pag-intindi ng democratic institutions ng impeachment process ng galaw ng hudikatura sa bansa.
Most definitely, dahil nakikita natin yung pag-function talaga ng mga institution natin, no? So we see how these institutions and how the Constitution is applied, dahil ang Constitution naman na nag-create dito sa impeachment court na to. So we see how the provisions of the Constitution are given life by this very impeachment. So it's very interesting to see that.
At bago natin ipagpatuloy ang ating talakayan, alamin muna natin ang saloobin at kuro-kuro ng taong bayan ukol dito sa paglilitis.
Ang pagkaalam ko sa impeachment ay nililitis yung mga matataas na opisyal ng gobyerno pag may nag-file ng complaint, tapos magko-convene ng isang korte na espesyal para litisin yung naakusa na government official.
Yung pong impeachment trial is yung pong isang tao na madami pong nag-complain sa kanya dahil po isa po siyang corrupt official. So, kailangan po siyang litisin para po mapatunayan kung isa nga po siyang corrupt official or not. Para po maging maganda, steady yung mga officials natin sa Philippines.
Para po sa akin, wala pang linaw yung impeachment. Kasi 5 days pa lang yung nakakaraan simula nung mag-umpisa yung impeachment. So, hindi pa masyadong malinaw yung mga ginagawa sa Senado. And sa tingin ko naman po ay kasi magagaling yung mga senador ngayon. Sige, tingin ko po magkakaroon ng linaw soon. Pero hindi pa natin masasabi ngayon.
Thank you.
At nagpapatuloy pa rin po ang ating talakayan. Kasama pa rin natin ang ating legal expert, Attorney Kaloy Ocampo, at syempre ang ating representative ng mga law students sa Pilipinas, Dino Austria. Attorney Kaloy, kanina nabanggit itong quantum of evidence, itong yung proof, no, proof beyond reasonable doubt, yung mga sinasabi nila para sa taong bayan na hindi masyado nakakaintindi. In-elaborate naman ni Congressman Angara ito. Pero sinabi rin niya na ang nagsilsilbing model natin ay itong US. Pwede bang kwentuhan mo kami ng konti kung bakit US ang nagsisilbing model natin dito sa pagsasagawa nitong impeachment trial?
Kasi after the UK in the 14th century, sumunod ang US. Silang next na gumamit ng impeachment process. And their history is very rich regarding this matter already. What we learned is, pwedeng magkaroon ng impeachment trial in a first world country like the US, and the nation will still run afterwards. It doesn't spell the end of their country. As a matter of fact, maraming nagsasabi na lalong lumakas pa after a demonstration that the Constitution is at work. And I think this is also true in other countries. The only difference with the U.S. system is that to bring it to the Senate, they need 50% plus one. Sa atin, one-third lang.
One-third lang.
And then another thing is, the justices in the Supreme Court of the U.S., they serve for life. So you cannot have one president appoint most of the justices in the Supreme Court like what we experienced here. Since they serve for life, then you can only expect a handful of changes during one presidency.
At kahapon din, no, itong isa sa mga na-discuss kahapon sa day 5 ng trial, itong wordings nitong Article 2, ilang araw na pinagdidiskusyonan itong paggamit ng mga salita. Ano, ito yung point of argument ng depensa at prosecution, yung paggamit ng suspected dito sa 2.3, if I'm correct, and 2.4. No? Can you explain to us bakit malaking diferensya itong dalawang salita na ito?
Well, suspected and alleged, I think, ang sinasabi ng depensa is speculative yan. Hindi kayo sigurado, walang personal knowledge. But ano talaga ang test? Sa aking palagay, the test should be, was the respondent, in this case the Chief Justice, put on notice what he's being accused of? Was he put on notice? The fact that he answered it, he said that wala siyang ill-gotten wealth, means he knows what the charge is about. So, para sa akin, hindi masyadong importante yung legal hair splitting on the words. Pangalawa, they're saying that hindi sakop ng heading yung mga allegations on ill-gotten wealth. But it's elementary in law na you have to harmonize the caption or the heading with the body. You cannot read them separately. In fact, if ever there is a conflict, a very serious conflict, it's always the body that will be controlling, not the caption. The caption is only just a guide to help you speed read through the document.
Kasi ito po yung argumento ng depensa, no? Ang sinasabi nila, Article 2 is about the non-filing and non-disclosure of the SAL and not about the ill-gotten wealth. So, the fact po, ang sinasabi nyo na nandun ito sa body, itong allegations of ill-gotten wealth, ay kasama pa rin po ito.
Yes, and don't forget, ano yung charge talaga sa Article 2? Ang charge or allegations sa Article 2 is betrayal of public trust. So all those other circumstances, facts, allegations, that is only the reason why the prosecution is claiming that the trust is the public is withdrawing the trust or has no more trust in the respondent. That's not the charge. The charge is betrayal of public trust through this and that. So Senator Escudero mentioned that there are 3 allegations or 3 charges. Actually, it's still one. Betrayal of public trust, and it's up to the prosecution to prove that the basis or the reason for the betrayal of the public trust is credible. It really exists.
Pero Attorney, parang sabi ng defense na hindi naman to betrayal of public trust. This is graft and corruption. Yung konsepto daw ng ill-gotten wealth, dapat graft and corruption siya. Therefore, it's in a different complaint or a different article.
It's betrayal of public trust. And the reason why they have no trust is because of the allegation of graft and corruption, non-filing of SAL, accumulation of ill-gotten wealth, etc.
At kani-kanina po lamang ay nakita natin na nagkakamayan itong si Lead Prosecutor Neil Tupas at Lead Defense Counsel na si Associate Justice Serafin Cuevas. Ready na po ang kapwa, ang prosekusyon at ang depensa. Ang oras po sa Senado, alas 2 na ng hapon at alas 2:01 ng hapon. Inaasahan po natin ang pagdating ilang minuto lamang, ilang sandali lamang nitong mga senator judges para umpisahan na naman po itong ika-6 na araw ng paglilitis laban kay Chief Justice Renato Corona. At kahapon nga ay maraming mga issues ang ni-raise attorney, and ang sinasabi ng prosecution ay mahalaga na umusad pa rin itong pagpepresente nila ng ebidensya at ng mga witnesses habang hindi pa nasa-settle itong mga issues na to. Bagaman sabi rin ng ilang senador naman na kailangan na mapag-agree muna nila o mabuon muna nila, pinalisan nila itong mga sagot dito sa mga issues na ni-raise bago mag-proceed sa trial. Para sa inyo po, ano po ba ang dapat na mangyari?
Huwag kayong magulat pero baka hindi matuloy ang trial proper ngayon because how can they after the first few objections, then they will have a problem again. Kailangan siguro i-resolve itong issue na to muna before they go back to the trial proper. That's just my guess. Of course, it's possible to proceed pending the resolution, pero mas maganda if they can resolve it right away.
So di na masasabi mo ba na yung kabataan medyo nawawalan ako ng interes sa nagaganap dahil nga marami masyadong technicalities?
Hindi naman, dahil naintindihan naman ng especially ng law students siguro that I represent na this is part of the process. That gaya na sabi ko kanina, that the impeachment has serious repercussions, so it's but natural for the defense to raise objections. It's their job. They won't be effective if they're not doing it. So we understand that this is part of the process.
And watching the trial, what can you say about how the senators carried themselves?
I have to say that it seems that they're very that they are impartial about the entire process, especially the presiding officer, Senator Enrile. Makikita mo naman na wala silang na wala silang kinikilingan. Kung siguro nagkataon lang that sometimes by the questions that the senators have asked, something may lumabas na dapat na itanong ng prosecution, dapat sila yung nagtanong.
Ito po, itong issue ng lawyering for the prosecution, ito po ay binabato sa ilan sa mga senator judges, at kahapon po ay nakausap namin si Senador Santiago at sinabi niya na bilang isang dating RTC judge, sa korte daw po ay although may freedom yung judge na magtanong dito sa mga witnesses at maging sa mga abogado, pero sinasabi niya na dito daw po sa impeachment trial, dapat daw po ay medyo bigyan lang ng konting leading, parang i-lead lang nitong mga senator judges sa tamang direksyon itong o sa gusto nilang malaman itong paglilitis, ngunit hindi nila dapat tanungin in such a way na they appear to be lawyering for either side, no? Although she hated to use the word lawyering. What can you say about it? What is your view on this?
First of all, right nila yun to ask questions under Rule 7, if I remember right. Pero dapat maingat rin sila sa choice of words because they don't want to be accused of bias. At the end of the day, it's up to the senator judges themselves to inhibit themselves if they feel na they cannot decide fairly anymore. And I think that's the issue with Senator Drilon. But so far, in my view, based on his line of questioning, hindi naman biased. He was just more effective, let's put it that way, than the congressman who was the prosecutor who was trying to elicit the evidence. That's why siguro there was a comparison. It took him only 5 minutes, whereas the lawyer was trying for 2 hours to no avail.
At nakikita na po natin nasa loob na po ng session hall ng Senado ang mga senator judges maging ang presiding officer na si Senator Juan Ponce Enrile. Panuurin po natin ang Day 6 ng paglilitis.
The impeachment trial of Supreme Court Chief Justice Renato Corona is hereby called to order. We shall be led in prayer by Senator Franklin M. Drillo.
Almighty God, we thank you for gathering us again today as an impeachment court to deliver justice. As we listen to all the deliberations today, may we be guided by the words of the Bible which says, "You shall do no injustice in court. You shall not be partial to the poor, nor defer to the great, but in righteousness shall you judge your neighbor." As we face this Herculean task, may your Spirit be with us. May your wisdom be granted to us, and may your fairness and righteousness be endowed upon us. All these we ask through Christ our Lord. Amen.
The Secretary will please call the roll of senators.
The Honorable Senators Angara, Arroyo, Cayetano Alan Peter Compañero, Cayetano Pia, Defensor Santiago, Dirilen, Ejercito Estrada, Escudero, Gingona, Honasan, Lacson, Lapid, Ligarda, Marcos, Osmeña, Pangilinan, Pimentel, Recto, Revilla, Soto, Trillanes, Villar, Senate President Enrile. Come on.
With 20 senators, judges present in the chamber, the presiding officer declares the presence of a quorum.
Mr. President.
Majority Floor Leader.
Mr. President, may I ask the Sergeant at Arms to make the proclamation?
Please proceed.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato Corona.
Majority Floor Leader.
Mr. President, I move that we dispense with the reading of the January 24, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Is there any objection? There being none, the January 24, 2012 Journal of this impeachment court is hereby approved. The Secretary will please call the case before the Senate sitting as an impeachment court.
Case number 002-2011, impeachment case of Honorable Chief Justice Renato Corona.
Majority Floor Leader.
Mr. President, may we ask the parties and or their respective counsel to enter their appearances.
Mr. President and members of the Senate, good afternoon. For the House of Representatives prosecution panel, same appearances.
Noted for prosecution.
Good afternoon, Mr. President and members of this impeachment court. For Chief Justice Corona, Your Honor, we are making the same appearance, Your Honor.
Noted for the defense. Majority Floor Leader.
Mr. President, in compliance with the directive given yesterday by the presiding officer, the prosecution filed this morning its memorandum, Article 2 of the verified complaint for impeachment with opposition to respondents' motion to quash subpoena issued to BIR Commissioner Jacinto Kim Henares. Mr. President, with both parties having submitted their respective memoranda and having argued their positions in open court yesterday, we submit that the issues have been fully discussed and the Senate is now ready to rule on the issue.
Thank you. This noon, at 12 o'clock this noon, the members of this impeachment court met in a caucus and considered both the memorandum filed by the prosecution at 10 o'clock this morning, as well as the memorandum filed by the defense panel yesterday morning, and we discussed the merits of both memoranda. And this impeachment court has arrived at a decision in that caucus that this court will allow the introduction of evidence on impeachment article number 2, paragraph 2.2 and 2.3, but not the introduction of evidence on paragraph 2.4. And so all parties must be guided accordingly. The prosecution may introduce, if it has, evidence that would support the allegations contained in paragraph 2.2 and paragraph 2.3 under Article 2 of the impeachment, articles of impeachment, but not on paragraph 2.3 of the same Article 2. 4 rather, excuse me. But not to introduce evidence under paragraph 2.4 of Article 2 of the Articles of Impeachment. So ordered.
Mr. President, Senator Drilon wishes to be recognized.
The gentleman from Iloilo.
Just to amplify Mr. Senate President, when the court ruled indeed that the court will allow introduction of evidence on 2.2 and 2.3, which would allow evidence to prove that evidence can be introduced that a property where the real personal is not included in the SALM. However, under Article 2.4, which asserts that such properties could be ill-gotten, the court did not rule on that and will rely on the presumptions of evidence, on the presumptions of law, particularly the anti-graft law, Mr. President. That's just as an amplification of the ruling of the...
That's correct.
Thank you, Mr. President.
Proceed, Majority Floor Leader.
Your Honor, please, may I... for only 1 minute, Your Honor.
The counsel for the defense, please proceed.
May we be informed, Your Honor, if there will be a written resolution of what had been disposed of today, so that we will be able to determine the exact parameters, the connotation and denotation of that resolution, Your Honor.
We do not have the resolution now. If that's the pleasure of the Defense Counsel, I'm now directing the Secretary of the Senate acting as the Clerk of Court to prepare a resolution to reflect this ruling of the Impeachment Court.
The ratio of the tariff, Your Honor, please, behind our request, Your Honor, is to be able to ascertain the next move on the part of the defense in connection with this resolution. Thank you, Your Honor.
Yes. The Secretary of the Senate acting as a Clerk of Court is hereby directed to prepare a formal resolution embodying what has been stated in the record just now as the ruling of this impeachment court with respect to Article 2 of the Articles of Impeachment.
Mr. President.
Mr. President,
Majority
please.
Floor Leader.
Yeah,
On
Mr.
the same
President.
matter, yes.
Yeah, on the same matter. With respect to the ruling and the clarification made by Senator Drilon, we reserve our right to file a motion for reconsideration upon receipt of the written order, Your Honor. Thank you.
Majority Floor Leader.
Mr. President, Senator Escudero wishes to be recognized.
Just a point of order.
Gentleman from Sorsogon is
Thank you,
recognized.
Mr. President. Just a point of order. It is my understanding that only a member of the Senate can seek a reconsideration from the ruling of the chair. Any rulings of the chair is considered the ruling of the Senate itself, unless a member of the Senate seeks a reconsideration or a vote in plenary from the same ruling and not by any of the parties.
That is a correct parliamentary rule, and I think that is followed in impeachment trials outside of this country. So I hope the prosecution is well advised.
Thank you, Mr. President.
Majority Floor Leader.
As earlier stated, the Council for Chief Justice Corona has filed a motion to quash the subpoena issued by the court to BIR Commissioner Kim Jacinto Henares. For its part, the prosecution has entered its opposition thereto. I move that the presiding officer rule on the motion.
With respect to this ITR requested by the subpoena filed with this impeachment court, the position of the chair is to allow the subpoena for the ITR of the Chief Justice and his wife. The ITR of the others included in that request, the prosecution must lay the basis or show the connection of those ITRs in the present impeachment case, which involves only the Chief Justice of the Supreme Court.
If Your Honor, please, if we may be allowed to say something about
the defense.
All the while I thought that with the proper resolution now of the denial by this honorable body, Your Honor, of the presentation of the evidence in connection with the legally acquired wealth, then the testimony of the Commissioner of Internal Revenue is precluded, Your Honor, because we were made to understand that the purpose of the offer of the testimony and evidence to be produced by the Honorable Commissioner of Internal Revenue is in connection with the ill-gotten wealth, Your Honor, and no longer in connection with paragraph 2 and 3, Your Honor. But with the definite ruling made by this Honorable Court that there could be no reception of evidence in connection with the alleged illegally acquired wealth, then that forecloses the avenue for opening up the opportunity on the part of the Commissioner to take the witness stand, Your Honor. That is our principal purpose, Your Honor, in making this manifestation, Your Honor. Sapagkat po maliwanag sa amin na hindi na po natin tatalakayin pursuant sa inyong order ngayon ang nauukol sa illegally acquired wealth. Sa amin pong paniwala at sa amin ang dating sa amin, hindi na natin pag-uusapan yan sapagkat may ruling na Unless that is reversed by a different authority, Your Honor, then they are precluded from presenting evidence in connection with this. So, it will appear now, Your Honor, that apparently there will be a contradiction in terms, Your Honor. This was disallowed, and yet evidence apparently are being allowed to be presented in connection therewith. That is our humble submission, Your Honor, based on our understanding of the order of this Honorable Impeachment Court, Your Honor.
The manifestation of the Council is well taken.
Thank you, Your
Proceed.
Honor. Mr. President, we are now ready for the continuation of the presentation of evidence by the prosecution.
Proceed.
Yes, good afternoon, Mr. President. Our first witness for today is the Commissioner of the Bureau of Internal Revenue, Ms. Kim Jacinto Henares. We call on our first witness, Mr. President, Your Honors.
What is the purpose of the offer of this testimony of the Commissioner of Internal Revenue?
The purpose, Mr. President, is the truthfulness of the entries in the SALN, and at the same time, the capacity to pay of the Chief Justice and the wife.
Wait a minute. The ruling of this chair is to allow the presentation of evidence with respect to the non-disclosure of the SALN of the respondent, and for the introduction of evidence with respect to the non-inclusion of assets and properties of whatever nature in the SALN. I see no materiality. The chair does not see any materiality of any introduction of BIR records with respect to these two allegations. So kindly explain and justify the introduction of evidence coming from the Bureau of Internal Revenue.
Yes, Mr. President, you want to prove the accuracy of in the SALN declaration, and for this purpose, may we call on the private prosecutor to conduct the direct examination. Attorney Art Lim.
There is none yet an order from this honorable body, Your Honor, allowing the introduction of evidence in this particular issue to be supplied by the Commissioner of Internal Revenue. So this will be out of order. I hope the court pardons me for emphasizing that point, Your Honor.
Mr. President, Senator Santiago wishes to be recognized.
Senator Santiago has the floor.
Mr. President, yesterday I proposed, and up to today, I Internal Revenue Commissioner. However, I wish to say the following. Number one, if the purpose is to prove veracity, she's incompetent to verify whether the income tax return states the truth or not. Number two, if the purpose is to prove allegations of unexplained wealth, that itself is also irrelevant because the court has already announced that it will decide on whether to accept evidence on the charge of ill-gotten wealth at a later time. That is why I want to ask counsel for the prosecution the following. Are you introducing this witness merely as an attesting officer to attest that that is the official tax return of the Chief Justice filed with her office, not as to the veracity? That's not possible. And number two, or are you introducing her as an expert witness? Later on, I will tell you why there is a difference between an ordinary witness and an expert witness. Could you answer the first question, please? Are you introducing her as an attesting officer or as an expert witness?
Yeah, the one, Mr. President, who will conduct the direct is Attorney
Hindi, dapat alam mo yan eh.
Please answer the question of the Senator.
Mr. President, with respect to the first question, we are presenting BIR Commissioner Kim Henares to testify on the truthfulness.
No, you can't. That is the ruling of myself and of the rest of my colleagues, I
The
hope.
veracity
You cannot
of the
testify to the
SALN.
veracity of an income tax return. You file the return with her. She does not go out and see if that is correct or not. That is the function of some office.
The question of the Senator is the character of the witness being presented. Is he going to be presented as an ordinary witness or as an expert witness?
Or some other form of witness.
Well, she's an ordinary witness.
Yes, she is. And the difference, counsel, is this. If you introduce her as an expert witness, you can ask her hypothetical questions. But if she is an ordinary witness, she will testify only as to her first-hand knowledge. Anything else will be hearsay. So, since she is I will not use the word merely, she's actually one of the higher officials of our country. Since she is in her capacity appearing here as Commissioner of Internal Revenue, she cannot possibly be examined, direct or indirect, redirect or recrossed, on whether the allegations in the income tax return are true. That cannot be the purpose. We're asking you what is the purpose. Your purpose simply is to prove that this is the piece of paper, the same piece of paper that was filed in your bureau, in her bureau.
The purpose, Your Honors, is the authenticity, to prove the authenticity of the
That's right.
documents.
She's only
that's
going to be
the
attesting
purpose.
that this is a,
Yes.
a correct and original, a copy of the original.
Yes,
Thank
that's correct. That's correct, Mr. President, Your Honors.
Mr. President, Mr. President, may we
The Majority Floor Leader,
recognize Senator Angara, Mr. President?
the Senator from Aurora is recognized.
Salamat po, Pangulo. That's the same point I'm going to raise, Mr. President, that the witness be allowed to testify, to authenticate, not verify the truthfulness or veracity of the document, because obviously she cannot do that. But she can certainly authenticate or attest to the truthfulness of that copy on file with her office. I think that
If we may be allowed to say a
no,
word or
because
so.
veracity
After your
already.
I'm sorry, Mr.
Yeah,
Senator.
Because if you say that it's to testify to the genuineness and veracity, then we are going to have a problem with paragraph 2.4, which the court itself said we will reserve judgment and ruling on that. I think that's the difference.
If Your Honor, please, if it is merely a question of authenticity, Your Honor, I would like to save the Honorable Commissioner of Internal Revenue from being saddled with the burden of coming here at the expense of what she should have done in her office. That matter can be testified to, if that's the only purpose, by any official of the internal,
Well,
or even
anyway,
the keeper of the records of the Internal Revenue, Your Honor.
Senator Dillon.
Thank you, Mr. President. The court has already ruled that the prosecution may introduce evidence to prove that there were assets that were not covered by the SALN. Only for that, and that is under 2.2 and 2.3. Insofar as ill-gotten wealth is concerned, the ruling of the court is that we will not rule on that as to whether evidence can be introduced on that point, but we will just let the documents be introduced, and the conclusion is a matter of law, and we will rule on that at a much later date. So that the court has already ruled, Mr. President, that evidence can be introduced on to show that there were assets not covered by the SALN. That's the ruling of the court under 2.2 and 2.3.
Anyway, the chair rules that the witness may testify only on the authentication. I would allow the witness to take the witness stand only to the extent of authenticating the due execution of the document.
If Your Honor, please, again we are compelled, much against our regret, Your Honor, to place on record our discomfort with the manifestation made by the Honorable Drilon. In fact, a lot of newspaper people said, hindi pa ba ninyo di-disqualify niyan? Apparently, she's already speaking. She's not ruling. He's not ruling, Your Honor.
Counsel, may I recognize Senator Drilon first?
Thank you, Your Honor.
We are just putting on record, Mr. President, the ruling of the court arrived at in caucus. Any member of the court can dispute that ruling, but apparent that it is clear that we were just stating for the record the ruling of the court as arrived at during our caucus. So it is not my manifestation. It is a manifestation of the ruling of the court as arrived at in caucus.
Anyway, let us now finish this argumentation. The chair will now allow the Commissioner of Internal Revenue to take the witness stand only to testify on the due or the authenticity of the document and due execution. So,
Submitted, Your Honor.
So we are calling now our first witness for today, Mr. President, the Commissioner of the Bureau of Internal Revenue, Ms. Kim Jacinto Henares. And may we request from Your Honors that Attorney Art Lim, one of the private prosecutors, be recognized to conduct the direct examination. Thank you.
Please,
what's the name of the private prosecutor?
It's Attorney Arthur Lim.
Arthur Lim.
Thank you.
The good and honorable Commissioner of Internal Revenue may take the witness stand and let her be sworn in.
Okay. Please stand and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this impeachment case?
Yes, I do.
So help you God.
Attorney Arthur D. Lim, private prosecutor acting under the direction, control, and supervision of the House Panel of Prosecutors, respectfully appealing, Your Honor, in these proceedings to conduct the direct examination of the witness, Honorable BIR Commissioner Kim Henares.
Proceed.
May it please the Court, and with your kind permission, Your Honor.
Proceed.
Madam Witness, good afternoon.
Good afternoon, sir.
Wala pa yan. Will you please state your name, address, and present position or occupation?
My name is Kim S. Jacinto Henares. My address is at 5th floor, National Office Building of the BIR, Diliman, Agcam Road, Diliman, Quezon City. I'm presently the Commissioner of the Bureau of Internal Revenue.
Your Honor, please, the prosecution is respectfully offering the testimony of the witness, BIR Commissioner Kim Jacinto Henares, in order to prove the following matters or facts. Number one, to show that respondent Chief Justice Renato C. Corona acquired properties as declared in his salens which are not justified by his income as reported to the BIR. Second purpose, to show that respondent tried to hide some of these properties in the names of his children, said properties being still owned by him are, however, not declared in his salens. Third and last purpose, to show compliance by the witness with the subpoena juris tecum et ad testificandum served upon her by this honorable court. May I proceed, Your Honor?
Your Honor, give me the opportunity to comment and or object. That is what the rules prescribe. Your Honor, please, we object to the purpose of the offer, Your Honor, because as we understood it, if the witness will be allowed to testify, she will be testifying on her personal knowledge, and that will involve the accuracy and the veracity of all that appears in the document that she will have to testify now. Secondly, my understanding, Your Honor, is any and all scintilla of evidence are proscribed by the ruling of this court in connection with the alleged illegally acquired wealth. So, any and all evidence that will be introduced in connection therewith will be immaterial, irrelevant, and impertinent, and therefore not admissible, Your Honor.
Your Honor, please, may I be allowed a brief reply, Your Honor?
Proceed.
The essence and the substance and the sum total of all these three purposes is authentication, which the Honorable Presiding Officer has expressly allowed.
Please explain.
Please note.
Please explain.
Please note, Your Honor. Yes, Your Honor, please. Please note that this representation never used the phrase ill-gotten wealth. And the witness will not be testifying about ill-gotten wealth. Maybe that belongs to another forum. The witness will simply authenticate public documents submitted to her office vis-a-vis the SALENs, which the witness knows as a matter of data.
Isn't counsel, isn't it that authentication refers to the requirements to establish the
Correctness.
the authenticity of the document itself,
Your Honor, please.
and not its contents?
Your Honor, please. Authentication in the legal sense is not simply to authenticate and make it a document that will be entitled to full faith and credit. In the first place, these are already public documents, notarized documents, public records, and they speak for themselves. So authentication in this sense is really not to request another witness or the witness here to discharge the additional burden of saying, yes, this is the income tax return of Mr. Corona, and I hereby certify that this is indeed authentic. There is no legal need for that, Your Honor, please, if I may humbly submit. Because
That was the understanding of the chair when he made the ruling and allowed this chair.
if that were the only purpose for authentication, in that very, very limited and constricted sense, I respectfully submit there is no need for any witness. All we have to do is to bring certified copies of the records. But again, Your Honor, what do we have in this case? This is not, of course, a criminal trial, but this is a trial for the high offense of culpable violation of the public trust, graft and corruption, betrayal of public trust, culpable violation of the Constitution, failure to disclose assets in the SALEN. The Honorable BIR Commissioner will declare that based on the figures taken at face value, reported under oath in the income tax returns, these figures cannot and can never justify the acquisition cost
Well, then that
for
goes
Villaggio,
Then that
for
goes,
the other properties that the respondent acquired. Sorry, Your Honor.
then that goes into the
Illegal.
substance of one of the allegations that was not allowed to be taken up in this court.
I was just
As
citing...
far as the form and compliance with the requirements of executing the SAL-N or the Statement of Assets and Liabilities are concerned, that is the one authorized by this chair to be testified on by the witness. And so therefore this chair rules that to the extent that you are going to look into the properties through this witness, that is disallowed.
Your Honor, please.
Your Honor, please, just one very brief reply, Your Honor, or
Yes.
manifestation to the extent necessary.
Go ahead.
I respectfully beg the Honorable Presiding Officer to direct a reconsideration or re-examination of the issue at hand so as not to limit the witness to merely stating that this is the document submitted to my office. The purpose, again, the number one purpose, with due respect to Senator Santiago, may I just restate the number one purpose and then I will end. To show that Respondent Chief Justice Renato Corona acquired properties as declared in his SAL-Ns, and the SAL-Ns are now before the Senate, which are not justified by his income as reported in
Then
his...
if that is in the SAL-N, the best evidence of what you're saying is the SAL-N itself.
We submit, Your Honor.
Correct.
Senator Santiago
I
wishes
think
to be recognized, Mr.
we
President.
are all familiar with the rules of evidence. that no testimony can vary the contents of a document, and this is a document. It's all subject to the best evidence rule.
Your Honor, please, we are not violating the parole evidence rule because the purpose is not to vary the terms or the content.
Precisely, counsel, I know that. But if now you admit that the salent is authenticated in accordance with complying with the requirements of the law in filing that document for its purpose, then in fact there is no need for this witness to be on the witness stand. The document itself will be sufficient to prove its content. That is the best evidence to prove the contents of that document.
I have received instruction, Your Honor, to accede, and I humbly accept the ruling of the chair. We will just...
The rule stands.
Yes, Your Honor. I am now ready to proceed, Your Honor.
Your Honor, please.
On that purpose.
Mr. President.
Allow me to be heard because there is an offer, Your Honor. If the only purpose, Your Honor, is authentication of the different documents in the form of income tax returns to be testified by the Honorable Commissioner, Your Honor, I'll go on record as posing no objection. Admitted. No objection. We assume we are willing to not only stipulate, but we admit, not stipulate, we admit that any and all documents relative to what is known as income tax returns are genuine and they are existing in the records of the Bureau of Internal Revenue, Your Honor.
Your Honor,
I request opportunity to speak. I have been here for 5 minutes. Out of courtesy to me as a Senator Judge, will you please keep quiet until the Senate President has acted?
Senator from Iloilo, so I apologize for not seeing the lady senator.
I know that
up.
the Senate President is hard of seeing, that's why he stood here. We have agreed among ourselves that to be visible to the Senate President, we shall stand up, even if he has not yet recognized us, for your information. Plus, please do not treat me as a mere observer. I am a judge in this proceeding. In any trial court, you go into a courtroom, you should not speak, you should not take any behavior at all, unless with the consent of the presiding judge. Do not drown me out by screaming in this courtroom. Only I can scream here, and my fellow judges. This is the first thing I want to say. I am in very strong support of the ruling of the chair. Number two, as already indicated, even before this witness came in, I already made the point that she cannot possibly testify as to whether the allegations in the income tax return of the accused or the respondent are true or not. All she can testify is, I have brought you an official copy of a record that has been filed in our office. That's all. She's merely an attesting officer. In fact, if prosecution had been on its toes, it should have asked opposite camp for a stipulation. Pwede magkasundo lang tayo sa pinag-uusapan dito. Ito ang income tax return ng Chief Justice na ni-file niya sa BIR. O, payag ka ba o hindi? O, di tapos na. Kasi yun lang sasabihin ng testigo eh. Hindi mo naman sabi, totoo ba itong mga nilistahan niyang ito? Wala, hindi naman siya nag-imbestiga. Kung meron man siyang mga tauhan nag-imbestiga, ang ginagawa nila, kung sa tingin nila ay nagkamali o nagsinungaling doon, ay ibibigay nila ang complaint nila sa fiskal, at ang fiskal ngayon ay magdemanda sa korte. At doon sa korte, malalaman natin kung totoo ba ang sasabi ng BIR, nagsinungaling ang tao o nagkamali lang ang BIR. Hindi yan dito. Kaya, maganda yung ginawa ng defense dahil sabi niya, ay kung yun lang palang pag-usapan, payag na kami. Hindi na kinanglan i-attest pa ni Commissioner, maraming ginagawa yan doon. So that is the present status of the proceeding. Ay kaya tayo tumagal dahil may oration pa eh. Huwag nyo kami i-orate dito. This is not a school on oratorical skills. This is a school of logic and experience. Ano bang istorya ninyo na ang Chief Justice nagnakaw ng pera? Yun ang mayor ninyong istorya eh. Ngayon, anong relasyon dito sa income tax return niya? I-establish lang naman ninyo, nag-file siya ng income tax return, ngayon meron kaming panibagong ebidensya na itong income tax return niya kulang. Meron pa siya ibang mga pag-aari, kaya mayaman siya. Kaya ngayon, pagtatanong ay kung pinayaman pala niya sarili niya, ay di siguro suspetyoso itong taong ito, hindi dapat manatili na Chief Justice. Yun lang ang pagtatanong. Huwag tayo dito naglalaban tungkol sa mga puntong ito. Nililito niyong publiko at nagagalit sa inyo Pakinggan niyo ang radyo.
Session suspended for 1 minute. Kung alam mo. Oh my God.
At pansamantala pong sinuspinde ang paglilitis laban kay Chief Justice Renato Corona. Inilabas na po ng Senado kanina ang resolusyon ng kanilang napagkasunduan sa kanilang caucus. Ito ay ang inanunsyo ni Enrile ang pag-allow ng introduction ng ebidensya sa impeachment sa Article 2, Paragraph 2.2 at 2.3, pero hindi papayagan ng Senado ang mga ebidensya para sa Paragraph 2.4.
So ito yung mga konsepto na sabi na sa 2.4, di ba, dito ina-allege ng prosecution na may suspected or accused of ill-gotten wealth ang Chief Justice. Baka importante matanong natin kay Attorney Caloy, bakit kaya dinisapprove ito ng Senate President?
Una-muna po, bago natin isasagutin yung tanong ni Gio, ano muna yung Article 2. Paragraph 2.2? Kahit buod lang po nito.
Hindi ko alam yung exact wording, pero ito yung paragraph na tungkol sa ill-gotten wealth. So, I think ito yung may impact compared sa ibang paragraph, ito yung may impact talaga.
Ito po yung
4.
2.4. Okay. Yung 2.2 po ay tungkol sa SALN. Ito po ba yun?
2.2.
2.2 tungkol sa SALN. At 2.3 ay tungkol naman sa
hindi pa
relatives. Mga relatives.
Properties of the respondent are not included in the declaration of his assets.
Okay.
So makikita natin, Attorney, bakit kaya hindi pumayag na magpresenta na ng ebidensya sa Article 2.4 ang ruling ng Senate Impeachment Court?
Well, mahirap magsabi kasi that the decision was reached in caucus, pero most probably because of the use of the words alleged and accused of, reported and accused of having not certain, not definite, no personal knowledge. Not, in other words, in the legal parlance, it's not a recitation of the ultimate facts as required under the rules of court for all complaints. So it seems that they were impressed by the argument of the defense on that matter.
Attorney, kanina rin ay nagsabi si Lead Prosecutor Neil Tupas na ire-reserve nila ang pag-aapela sa ruling na iginawa ito ng Senado hanggat hindi nila nakukuha ang kopya ng resolusyon. Ngunit nagsabi naman si Senate President Juan Ponce Enrile na pinal na ito at hindi na nila maaaring iapela itong napagdesisyonan na. Ito po ba, ano po ba yung nakasaad sa rules of impeachment pagdating dito sa pag-aapela ng mga desisyon ng Senado?
Actually, medyo nagulat ako sa ruling ng presiding officer, Senator Enrile, because it's basic that if there is no rule, in this case the Senate rules, prohibiting such an action on the part of counsel, it's possible. It's not automatic, but it's possible. So for the Senate President to immediately say that it's not allowed, I think went beyond the scope of the Senate rules. There are two provisions. Yung isang provision kasi regarding questions on evidence. In that case, it's really the Senate, it's expressly stated here that the senator judges, the other senator judges, can question. But it doesn't say anything about the counsel. In another provision, which I feel is more applicable, it's very specific. They have, counsel have the right to file motions. And all motions, objections, requests, or applications, whether relating to the procedure of the Senate or relating immediately to the trial, including questions with respect to admission of evidence or other questions arising during the trial, may be made by the parties or their counsel addressed to the presiding officer. And that's exactly what Congressman Tupas did. But unfortunately, I think the Senate President was not aware of this rule in their Senate rules, and he denied the request, I believe.
So, pag ganito po, sinabi na po ni Senate Presiding Officer Juan Ponce Enrile na pinal na po ito, maaari pa po bang i-invoke ng prosecution itong rule na ito at sabihin na iaapila pa rin nila?
Kung ako sila, I would, very politely. So, I would give it a try. But let's see what they do. It seems in open court, the senators can be very intimidating. And as you can see from the body language of the counsel, even the senior counsel, you know, they're also affected whenever the senator judges or this presiding officer get irked or upset.
Siguro makikita rin natin nga sa action si Senator Miriam at sa opening statement ng prosecution at sa defense sa pagpresenta sa bago nilang witness for today, si Commissioner Kim Henares. Bakit yung nabigay yung scope nung pag-testify tungkol sa authenticity ng mga dokumento na nais ipresenta ni Commissioner Henares?
Well, I am a little confused because si Congressman Tupas, I'm sorry.
At nagbabalik po, nagpapatuloy po ang paglilitis.
Thank you, Mr. President. I will just ask one question. Commissioner Henares, have you obtained the authority of the President to reveal the income tax returns under question?
Yes, sir. I have obtained the authority from the President, sir.
Thank you.
The counsel for the prosecution may proceed.
Thank you, Your Honor. With your kind permission, Your Honor, please. Madam Commissioner, do you know if there is a government official in the Philippine government who is vested with sole, exclusive, and original jurisdiction to interpret tax laws and to decide tax cases administratively?
Yes, sir.
If Your Honor,
Preliminary, Your Honor.
Yes, but you do not know what my objection will be.
You state the legal ground. Yes. But this is preliminary.
The question
counsel for the defense state his objection.
The question, Your Honor, calls for an opinion. And the way we understood it, the Honorable Commissioner is being presented as an ordinary witness, Your Honor. That is my objection.
Well, he is the Commissioner of Internal Revenue, and the court takes judicial notice of that.
Thank you, Your Honor.
Proceed.
Does the chair allow the question, Your Honor?
That's why I said proceed.
Please answer.
Yes, sir.
Who is that official?
The Commissioner of Internal Revenue.
Is there any other government official who exercises that power concurrently with the
That's a
BIR
matter of law.
Commissioner?
That's a matter
No,
of law.
sir.
Yes, Your Honor.
That is a matter of law. That's taken judicial notice of this body are the makers of the law.
Thank you, Your Honor. Since when, may I proceed, Your Honor?
Yes.
Since when have you been BIR Commissioner?
I assumed my office on July 2, 2010.
What are your duties and responsibilities, ma'am?
I implement the National Internal Revenue Code and all tax laws relating to internal revenue.
Why are you now before this honorable impeachment court?
I received a subpoena from the impeachment court last January 18, 2012.
You earlier told the Honorable Senator Joker Arroyo that presidential approval for disclosure has been obtained. On that premise, Your Honor, may I now proceed also by way of compliance with the directive?
What is the purpose of presenting the income tax returns of the respondent?
To authenticate, Your Honor.
Huh?
And I am now proceeding to...
No, I'm asking the purpose, the purpose.
For presenting the income tax returns,
Yes.
Your Honor, to explain that as per the figures indicated therein, which should be taken at face value without interpretation, without opinionating as to how these figures were arrived at, the figures declared under oath in the income tax return in no way and can never justify.
That goes into the testimony of this witness as offered is to authenticate.
Yes, Your Honor. I will
And
now...
the authentication, it goes into the compliance with the form of the SAL, and the contents of the document presented by the witness, as you have not presented the SAL that was brought by the witness.
Yes, Your Honor.
So present it first.
I am very much aware of the ruling to just merely
Yes.
limit the question. So I am proceeding to
We are
that.
not dealing with the authentication of the income tax return. We are talking about the statement of assets and liabilities and net worth of the respondent.
Yes, Your Honor, but the purpose why the BIR Commissioner is here is precisely to produce before the Honorable Impeachment Court the income tax returns or income documents as reported and filed with the BIR by the respondent herein.
The distinguished senator from Makati and
Thank you, Mr. President. I hate to interrupt, but I think the defense has... Have you stated that you accept the authenticity of the...
It is not merely a stipulation, Your Honor. We went on record as admitting that the documents identified by the witness, by the Honorable Commissioner, especially the income tax returns, are authentic, Your Honor. So what is... that dispenses of proof, Your Honor.
Can I now proceed to to enter into the record the documents and mark them as exhibits?
Mr. Lim, please do not. I have yet the floor.
I'm sorry, sir. I'm sorry.
Well, if that is the case, to speed up the process, there's no dispute as to the authenticity, so there's no argument. Yes, both sides have agreed. You present it, and that's it.
Mr. President.
Since the defense admitted that the income tax return involved is the income tax return of the respondent, what income tax return is this? For what years?
Your Honor, please, with the indulgence of Senator Santiago, may I also respectfully point out so that...
No, the chair is asking, for what years are these income tax returns?
The subpoena, Your Honor, is at least from 2002 up to 2010, but there is one... 2010, Your Honor.
From
1992 to 2010.
But we are talking of an impeachment case of the Chief Justice of the Supreme Court. And whatever he did before he was a Chief Justice, that has no bearing as far as this chair is concerned with the impeachment.
This is precisely why, Your Honor, my presentation, the presentation of the sample representation starts only from 2002. Your Honor, please, may I be allowed to make a manifestation in order...
Then if you want, what is the pleasure of the counsel?
Honor,
do you
please.
accept that the Chief Justice filed income tax returns from 2002 when he became a Justice of the Supreme Court until today?
Anyway, if Your Honor, please, may I be allowed to explain first? I understand that what the Honorable Commissioner will testify now is only with respect to these income tax returns, Your Honor. We have already admitted that they are all authentic and genuine, Your Honor. So that issue is already taken out of the presentation of evidence. Secondly,
yeah, but they're asking for the introduction of the those income tax returns.
They will be impertinent, Your Honor, and I reserve my objection at the time they make the offer, because these are documentary exhibits, Your Honor.
Your Honor,
Unless they made the offer, we are not yet allowed under the rules to object or to make any
then
observation.
why don't you then wait until those documents are actually offered in evidence in this case?
One very important point of clarification, Your Honor. Please allow this representation,
Go ahead.
Your Honor. The Chief Justice, Renato Corona.
Just a minute. A member of this court.
Senator Santiago, Mr. President, wishes to be recognized.
Thank you very much. Nagkasundo na pala tayo eh. Ang pagtatanong lang ay, saan ang income tax return ng Chief Justice? Dahil dyan tayo mag-uumpisa at pakita natin sa kinabukasan na hindi tama yung mga pinagsasabi niya doon. Eh nagkasundo na tayo. Itong ni-file sa BIR, tapos na. Wala na. Ngayon, marking na lang of the documents, it can be done with the clerk of court outside with two parties represented there. Wala na tayong pinagtatanong pa dito. Next witness na dapat.
Your Honor,
I kindly submit, Mr. President, that
Please do not
these
interrupt.
steps would be pursuant to the direction that your comments have been taking so far. Tapos na itong babaeng ito. May trabaho pa ito. Pauwiin mo na yan. Markahan mo ng papel.
Your Honor.
Ayun lang ang pwede niyang sabihin eh. Bakit may first-hand knowledge ba siya? Pag sinulat mo dyan, pag-ari ko ito, sa itong kalye na ito, pag-ari ito ng asawa ko, bakit inimbestiga ba yan? Wala siyang first-hand knowledge. She's testifying on hearsay, except that the rules provide that these documents, being official documents, shall have prima facie evidentiary weight. So, at first glance, yun na nga ang katotohanan hanggang sa meron palang ibang ebidensya na hindi totoo yung mga pinagsasabi. Ano naman masasabi ni Commissioner of Internal Revenue tungkol dyan? Dahil hindi naman siya nagde-decide yan eh. Ang korte, an ordinary court of justice. So I think we should abbreviate the proceedings. Markahan ang dokumento and call your next witness. Huwag mo kaming pilitin ng ayaw namin gagawin. Nag-ruling ng presiding officer sa iyo eh. You cannot prove anything is true or false until you have the proper witness to do so, and she is not the proper witness. So, bakit natin patagalin ito? Eh, sinabi na ng presiding officer, tama na eh, sige ka ng sige eh. You're already in danger of contempt.
May I explain?
Your Honor, please.
Just a minute. May I explain the position of the chair? No? The situation is this. You said that you want to present these income tax returns. The counsel for the defense, yung abogado ng respondent, hindi tinatanggihan na yung mga income tax return na yan ay income tax na nakasakdal na Chief Justice. Ngayon, kung ano man linalaman yung income tax na yan, ay walang ibang prueba kung hindi yung income tax return. Ngayon, kung meron kang ebidensya na ang Chief Justice ay nagkaroon ng ari-arian na hindi naisama dyan at hindi naisama sa SAL, ay ipresenta mo yung ebidensya na yun. Because kung itong Commissioner ng Rentas Internas ang magsasabi sa akin, ay tatanungin ko sa kanya, bakit hindi mo inassess ang income tax na dapat mong kolektahin dyan bago ka pumunta rito?
Your Honor,
Ayun.
Your Honor, please, can you kindly allow one brief manifestation?
Go ahead.
There are no income tax returns filed, Your Honor. There are no income tax returns filed. This is the problem.
There are no income tax returns for what years?
Filed by Chief Justice Renato Corona from 2002 to 2010. This is what I have been itching, pardon the use of that word, to manifest before this honorable body, because Chief Justice Corona is what is termed in the BIR a local employee. He does not earn income from business. Therefore, the income of the Chief Justice from 2002 up to 2010.
Well, you're now precisely. Well, I will tell you that I will disallow that kind of and evidence because you are proving paragraph 224 through the introduction of the income tax return of somebody, and then you will conclude that the money came from the Chief Justice.
Please allow me to complete, Your Honor. I beg the Chair. Chief Justice Corona, being what is termed a local employee, not engaged in business, does not file income tax returns. He is what is called listed in the alpha list of the Supreme Court. His taxes are withheld on a monthly basis, quarterly reporting, and yearly the Supreme Court submits to the BIR an alpha list containing all the names of the justices and the employees of the High Court to the BIR. So it is really necessary to conduct some direct examination to the witness so that the income will be authenticated.
But there
not
is
explained, but authenticated.
You do not authenticate the income. I
No,
thought
the alpha list,
Your
Your
Honor,
Honor.
please. I thought it was being...
Counsel, please, for the defense. Go ahead.
If that is directed to the defense lawyer, Your Honor, may I make this manifestation? I thought we were agreed on the proposition that the purpose of introducing the Honorable Commissioner of Internal Revenue is merely to authenticate and nothing more. To shorten the proceedings and to help my good friend, Your Honor, I am willing to admit, not only stipulate, but admit that any and all documents pertaining to the income tax returns of the Honorable Chief Justice Corona, we admit that they are authentic. What more?
Can I proceed?
Maliwanag po ang aming pag-amin. Hindi namin tinututulan na authenticated yan. Ano pa pong bibistahan dito? Kung yun lang ang
There
purpose.
rules that the proposed introduction of the income tax returns of other than the Chief Justice and his wife is not authorized.
Yes, Your Honor. We submit to that ruling. We only propose to limit the introduction of income evidence as far as the Chief Justice and his spouse are concerned. But there is a practical problem.
I thought you are authenticating the sal end of the Chief Justice. That was the representation.
That has been presented in the past hearings, Your Honor.
What is that?
My appearance today is for the income tax returns, Your Honor. The sal ends were brought by the Clerk of Court of the Supreme Court. That was on the third day of the hearing, Your Honor.
It is the ITR that you want to authenticate.
That is the subject of the hearing today, yes, Your Honor.
Who's ITR?
Renato Corona and Mrs. Cristina Corona,
All
Your
right,
Honor.
proceed.
Thank you, Your Honor.
Yeah, proceed to authenticate the ITR of the pertinent ITRs of the Chief Justice.
Thank you, Your Honor. Madam Witness, did you bring the ITRs or other income documents of Chief Justice Renato Corona as required in the subpoena?
The question, Your Honor, is too general. And other documents, what are those documents?
Specify.
Fine.
I beg permission to delete that phrase.
Thank you. So will you kindly reform the question for the better understanding
It's
of the
the
witness?
chair who should be making the ruling, Your Honor. That's not counsel.
May I...
No, I object.
That's why-
Your Honor.
Order.
That's why I'm making a manifestation.
May
Will you kindly-
I request the counsel for the defense not to make any remarks that will cause irritation to the...
I apologize, Your Honor,
to the
especially
counsel
to
for
my
the-
learned colleague, Your Honor.
the lawyer representing the prosecution. Proceed.
With your kind permission, Your Honor. Madam Witness, please tell this Honorable Impeachment Court whether Chief Justice Renato Corona filed income tax returns for the period 2002 up to 2010 as required in the subpoena.
He did not file any income tax return for tax year 2002 up to 2010.
Do you, however, have a record of his income considering the function of the BIR?
Record of income, Your Honor. May we be permitted to place on record our objection. Again, this tends to prove that which is prohibited by the order of this honorable court, Your Honor.
No, Your Honor.
Counsel
We are very
for
clear on that.
No, Your Honor.
order. Mr. Counsel for the prosecution, you are asking if the Chief Justice filed any income tax return for the years involved, and the answer is no. That's the end of the matter. If the BIR commissioner wants to prove that there are other income, then do it. You have to make the assessment. And if you make the assessment, present it in this impeachment court. That's the proper thing to do.
May I proceed, Your Honor?
Yeah.
Madam Witness, will you kindly tell us what is an alpha list?
May we know the purpose, Your Honor?
What is the alpha list?
Preliminary, Your Honor.
Yeah, preliminary to
Not
what?
every question has to be indicated as to purpose, Your Honor. We respectfully take exception.
Let the witness answer.
The alpha list is a document enumeration of all employees of a certain employer, their income earned and the amount withheld from them. And these are submitted by the employers at the month after the end of the year. No? And because of Section 51 of the tax code, this takes the place of the income tax return for certain employees under Section 51 of the tax code.
If Your Honor, please.
Well, the counsel
Your Honor,
for the defense.
We move to strike out, Your Honor, the answer of the witness because it is irrelevant, immaterial, and nothing connection with the alleged authentication problem, Your Honor.
Let me expand from the record. You have not laid down the basis. What is the connection of what they call it?
Alpha list.
Alpha list. And you have not even identified whose alpha list that is. Huh?
We submit, Your Honor. May I proceed, Your Honor?
Alpha list.
Is Chief Justice Renato C. Corona the respondent in these proceedings a registered taxpayer?
Admitted, Your Honor.
What is his TIN? Will you please state it for the record, Madam Witness?
That.
TIN, Taxpayer Identification Number.
Again, we will object to the question, Your Honor, on grounds of immateriality, irrelevancy, and not...
why should...
I am laying the basis, Your Honor, please. So I'm sorry for butting in, Your Honor. May I proceed? May I proceed, Your Honor? I'm laying...
The tax in the identification number.
Your Honor, please, I am precisely laying the basis for the introduction of evidence that in lieu of ITR, which is normally the document filed by a regular taxpayer, a person earning income solely from a certain outfit, government or private, does not file income tax return, but is merely reported regarding his income as well as tax withheld by his employer. And it is in this light that we are asking the witness, what is alpha list? But since that alpha list question was disallowed, I am proceeding to lay the basis that firstly, the respondent is a registered taxpayer, therefore he has a TIN, and the next question would be, how is he registered as a taxpayer? Local employee or engaged in business?
Your Honor, please.
We are in search of the truth here, Your Honor.
If Your Honor, please. If Your Honor, please.
Counsel for the defense.
I thought we were agreed, especially when we hear the purpose of the offer, that the Honorable Commissioner is being introduced only to authenticate the documents that will be identified and presented in today's proceeding. Where is the authentication here?
How?
Is it too far behind, too far, not covered by the purpose of the offer, Your Honor?
Your Honor, please, how in heaven's name can the alpha list be authenticated when it also contains the income of other justices for whom no disclosure authorization has been granted. So there is a need to elicit certain facts from the witness.
We submit, Your Honor, entirely out of the purpose, Your Honor, and that is prohibited by the rules of procedure, and even under pre-trial proceedings, Your Honor.
Because there is already a ruling by the Honorable Presiding Officer that the prosecution can now proceed to authenticate and make of record the income. My only purpose of whom? Renato Corona, the respondent, Your Honor, and his spouse.
But the income tax return, as you said, is not there.
It is in the alpha list that the BIR commissioner will testify on. He has the alpha list, and I request permission to allow the witness to show the alpha list. It is a very thick document. The only thing that will prevent the witness from identifying or marking the alpha list is it contains the names of other taxpayers, all justices of the Supreme Court. We cannot reveal their individual income without authorization, and they are not yet, I remove the word yet, they are not under impeachment proceedings, Your Honor.
Malapit na pala. Wag naman.
I'm sorry for that, Your Honor.
Kawawa naman sila.
Let me understand this alpha list. Does the alpha list contain?
Yeah. I beg your pardon.
What does it contain?
The alpha list, Your Honor, contains all the names of the employees. It is a listing of all employees of the Supreme Court, including justices, and how much income or salaries they have been paid monthly, how much withholding tax has been withheld by the Supreme Court, and how much has been remitted by the BIR to the Supreme Court by way of withholding tax, which is the tax payment by these employees, including the justices.
All right. Para maintindihan ng publiko, ito.
If you have friends abroad, if you have friends back in Manila, katulad namin, tinetext na namin yan, manood kayo.
Napapanood ka ngayon.
Respondent ay hindi nagbayad ng tax.
Kung magkano po ang buwis na kanyang binabayad by way of withholding tax, at kung magkano ang kanyang kinikita po buwan-buwan, Mr. Presiding Officer, wala pong income tax return kaming madadala at maipakita sa
wala bang
hukuman.
income tax return ang Chief Justice sa mga anong taon?
From 2002 po, Your Honor, up to 2010, hindi po siya nagpa-file ng ITR dahil hindi siya obligado sa loob ng sa ilalim ng batas. Wala po siyang income bilang business or bilang wala siyang other income, Your Honor, other than his salaries. And if a taxpayer earns income solely as a local employee, that is the technical classification, meaning purely an employee of a certain company or a certain government office, hindi po siya nagbabayad na ng income tax return. Kinakaltas na lang po yung kanyang withholding tax. Employer ang gumagawa po noon.
Dahil ang pinag-usapan natin dito ay authentication ng dokumento.
Ipa-authenticate ko po yung alpha list as far as Corona is concerned.
Will you please allow the presiding officer to...
My apologies, Your Honor. My sincere
apology accepted. Dahil ang pinag-usapan natin dito ay dokumento. Yung income tax return ng respondent o yung kanyang SAL-N. Ay, sinabi mo, walang yung SAL-N dito, walang income tax return. Ngayon, gusto mo ipakita ang linalaman noong ano ba ito? Alpha list.
Opo, para malaman po ng hukuman kung magkano ang kinikita ni...
Ipresenta mo yung alpha list. That is the best evidence ng linalaman ng dokumento.
Wala po kaming disclosure authorization. May pangalan.
Paano mo gagawin niya? You cannot.
Yes, Your Honor. Yes.
You present the alpha list.
Yes, Your Honor. Madam Witness, will you please produce the alpha list from the Supreme Court?
That's the best evidence.
Your Honor, please, may we be allowed to
Counsel.
make a manifestation
Yes.
in this regard with the kind permission of the Honorable Presiding Chairman. All the while, Your Honor, we thought that in today's proceedings, they will be presenting the ITR of the Honorable Chief Justice
Wala
Corona,
nga eh.
Your Honor. In fact, we went on record as admitting that all these are authentic. It's only now that we find out that they do not have, allegedly, the records of the income tax returns of the Honorable Chief Justice Corona. In that case, Your Honor, the issue of authenticity is beyond the issue that should be resolved here. Now, we were informed by our co-counsel here that in the markings that was made this morning, no income tax returns of the Chief Justice was presented or marked, Your Honor. So, what is it that they said in the, what is it that falls under their purpose that merely to authenticate? What is it? What is
Well,
it?
anyway, the chair has ruled that let them present and submit that alpha list for the consideration of this impeachment.
Submitted, Your Honor.
Thank you, Your Honor. Will you please, may I proceed, Your Honor, please?
Proceed.
How much was the income?
The best evidence rule applies. I already told you, Mr. Counsel, do you understand
We
the
cannot
best
leave
evidence
that,
rule?
We cannot leave that here, Your Honor.
Huh?
We cannot leave this here. It's a confidential document containing...
Then I will disallow it.
Mr. President, may we recognize Senator Ralph Recto?
The gentleman from Batangas.
Thank you, Mr. President. Ginoong Pangulo, para mapabilisan natin yung proseso dito, palagay ko, base sa pagkaintindi ko, ang sinasabi ng prosecution dito, para mailabas natin ang katotohanan, ay sinasabi nila na kaya mahalaga ang testigo ito para ipalabas magkano ang buwis ang binabayaran ng Chief Justice at magkano ang sweldo. Base sa mga dokumento na binibigay ng Supreme Court sa BIR at yung mga withholding taxes na wini-withhold ng Supreme Court. And dahil dyan, kung maaari po ako magtanong sa testigo to abbreviate the proceedings. No? Hindi para pumanig sa sino man. Ginoong Pangulo, tatanungin ko sa ating testigo, sa taong 2002, magkano ang buwis na binayaran ng Chief Justice?
Sa taong 2002 ho, ay hindi ho nag-file ng alpha list ang Supreme Court at hindi rin ho nag-submit ng income tax return ang Chief Justice Corona ho. So wala ho kaming record.
Wala kayong record kung magkano ang buwis na binayaran ng Chief Justice na winitold ng Supreme Court na dapat ibinigay sa BIR for the year 2002?
Wala ho.
Wala.
Wala.
Pero hindi nangangahulugan na hindi siya nagbayad. Dahil trabaho ng Supreme Court ang kumaltas at mag-remit sa BIR. Tama ho ba yun?
Tama ho yun.
Okay. Sa taong 2003, magkano naman ang buwis na binayaran ng Chief Justice?
Ganun rin ho ang nangyari sa 2003. Wala hong income tax return final ho ang Chief Justice Corona at wala rin hong alpha list sinabmit ang Supreme Court.
And to be fair, Mr. President, hindi nangangahulugan na kailangan siya magkaroon ng income tax return kung wala naman siyang other income. Tama ho ba yun?
Nasa
so walang bawal dyan?
Wala ho. Nasa Section 51 ho yan ng National Internal Revenue Code of 1997.
Tama po yun. Sa taong 2004, magkano naman ang buwis na binayaran ng Chief Justice?
Ganun rin ho. Wala ho siyang final na income tax return at wala rin hong binigay na alpha list ang Supreme Court.
Okay. Sa taong 2005, ganoon din po ang katanungan. Magkano ang buwis na binayaran ng Chief Justice? Base sa mga records ninyo.
Ganun rin ho. Wala rin ho siyang final na income tax return at wala rin hong final na alpha list ang Supreme Court.
Okay. Sa taong 2006,
Aha.
2006, magkano ang buwis na binayaran o winithhold ng Supreme Court at ibinigay sa inyo na mula sa Chief Justice ng Supreme Court?
Ang winithhold ho ng Supreme Court ay 109,706.60 based ho sa gross compensation ho na 465,597.
So makatuwid, yung 400 plus thousand na binabanggit mo, yun yung income ng Chief Justice na binawasan ngayon yung 100 plus thousand na binabanggit ninyo.
Oha.
Okay. Sa 2007, magkano naman? Yung brief na binayaran ng Chief Justice na winithhold ng Supreme Court na binigay sa Bureau of Internal Revenue.
Based ho sa alpha list na sinabito ng Supreme Court, ang binayaran ng buwis ay 117,399.31.
At yung income,
488,156.57.
halos pareho nung 2006.
Aha.
Sa 2000, nasa na ba tayo? 2007 o 2008 na ba? 2008. Ganun din po ang katanungan.
Ang winithhold ng buwis ng Supreme Court ay 154,057.75. Ang gross income ho ay 604,388.46.
For what year?
For 2008 yun.
Aha.
Sa 2009 naman po,
Sa 2009 ho, ang winithhold ho na buwis ay 109,706.60. Hindi, 206 ito. Sorry po. 2009. Sa 2009 ho, ang winithhold na buwis ay 155,556.20. Ang total gross income niya ho is 621,528.62.
parang hong lumaki nung 2009. Ito ba'y dahil sa pagtaas ng salary standardization law?
Siguro ho, wala ho ako.
Okay, fair enough.
2010.
Sa 2010 naman po,
Ang withholding tax ho niya ay 176,577.32. Ang total salary ho niya, taxable salary ho, ay 657,755.57.
okay. Sa madaling salita, ang meron lang kayo record from what year again? 2005?
2006 hanggang 2010.
10. Meron ba kayo record from 92 to 2001?
From those years ho, kasi nag-dispose na ho kami ng mga records namin. No? Meron hong rule na nagdi-dispose ng records. So. Pero meron...
For every how many years in disposal yun ng records? 10 years?
I don't really, because hindi ho ako yung commissioner na nagbigay ng orders for
Pero
disposal.
ano yung nakasulat sa batas tungkol dyan? 10 taon? Na dapat tinatago?
10 taon? Wala ho ako noon batas na yon ho. Meron lang ho ako ang kopya ng Revenue Memorandum Circular number 73-2008 wherein ho nagkaroon ng record disposition schedule ng mga returns, mga dokumento ho. So kasama ho yung mga returns. Ang meron lang ho kami a computer printout noon na encode na return for 1997 and 2001. The Chief Justice Renato Corona ho.
So meron kayong computer printout?
Ng 1997 ho at ng 2001.
2 taon lang? Pero wala yung mismong income tax return?
Wala ho.
Kung meron man income tax return?
Dahil naka-encode, kasi ho yung proseso, pag file ng return, tinatanggap ho ng bangko, pinapadala sa BIR, at ang BIR ho ay nag-e-encode ng mga data ho.
Hindi, tama po yan. Hindi, ang pinag-uusapan natin,
yung
hindi
return
form
mismo.
ng income tax return.
Wala ho.
Actually, ba? Okay. Pero masasabi ba ninyo na hindi nangangahulugan, na hindi
na withhold yung salary ng Chief Justice ng Supreme Court. Lagi naman lahat tayo sa pamahalaan, withhold yung taxes bago natin makuha yung income natin tuwing 15 o 30. May withholding na kaagad or every, di ho ba? Kinakaltasan kaagad yan.
Ang dahilan ho kung bakit ho alpha list lang ho ang meron kami at hindi ho income tax return dahil ho sa Section 51 ng National Internal Revenue Code at sinasaad doon ho kung ikaw may isa lang hong nagtatrabaho lang kayo sa isang employer at tama yung pagkaltas sa inyo, hindi na ho kayo magpa-file ng income tax return kasi ho yung alpha list ho ng employer nyo ay sapat na hong return yun.
In other words, with the permission of the gentleman from Batangas, Madam Commissioner, in other words, your alpha list is in lieu of income tax return.
Yes, sir.
Okay.
Proceed. Wala na po akong katanungan, Mr. President. Maraming salamat. Masakit lang na pag nakaupo ka hindi nagkakaintindihan. Kaya tumayo na tayo para may palabas lang natin ito. Maraming salamat po.
So, Mr. Counsel, for the prosecution, proceed. What is there to authenticate?
Thank you, Your Honor. I will now proceed to Mrs. Cristina Corona's ITR, Your Honor.
What is the relevance of Cristina Corona to the
There was
this
a
impeachment case?
I respectfully invoke the ruling of the Honorable Chair that the income tax returns of the spouses Corona, meaning Chief Justice and his wife, will be a proper subject of direct examination or inquiry in these proceedings. The Chair only excluded, I think, the children, if I am not mistaken.
Are you going to make an examination of the contents of the Internal Revenue income tax return of the respondent for the years mentioned?
Yes, I will be asking similar questions, similar to those propounded by Honorable Senator Recto, Your Honor.
But isn't that document the better evidence of its content?
There is again this problem of alpha list, if I may use the word problem, Your Honor.
Proceed.
Thank you, Your Honor. Is Mrs. Cristina Corona a registered taxpayer as far as the BIR records are concerned?
Yes, sir. She is a registered taxpayer.
Did you bring with you, Madam Witness, what the subpoena referred to as income tax returns of Mrs. Cristina Corona from the year 1992 up to 2010?
Again, sir, she did not file any income tax return, and I would like to make she was registered only as a taxpayer in September 9, 2003. So any year before that, she's not a taxpayer.
Let me be more specific for the record. From 1992 to 1996, are there income tax returns in your record filed by Cristina Corona?
If Your Honor, please, at this juncture, we hate to object, Your Honor. But insofar as Cristina, because she is the wife, Your Honor, and she is covered by the resolution of this honorable court. Cristina is the wife, Your Honor.
No, but she's not the one testifying.
Correct, Your Honor.
It is the Commission of Internal Revenue with respect to an income tax return of the wife.
But these are evidences, Your Honor, against her when she is not a respondent here, Your
Witness may
Honor.
answer.
May the Secretariat kindly read the pending question if it is all right to request a reading?
Proceed.
Otherwise, Your Honor,
You can propound the question again. So that,
thank you, Your Honor.
To cut short the proceeding.
Yes, Your Honor. Madam Witness, do you have in your records income tax returns of Cristina Corona for the years 1992 up to 1996?
No, sir. She did not file any income tax return, and neither is she a taxpayer during those years.
What about from 1997 to 2005?
She did not file her income tax return, and we don't have it.
What about for the years 2006 up to 2010?
She did not file her income tax return for those years.
When did she become a registered taxpayer for the first time?
September 9, 2003.
In connection with what?
She registered as a one-time taxpayer for a property transaction.
Do you have in your record what property transaction is that?
Yes, sir. It's the La Vista property, sir.
Will you kindly elaborate?
No, the chair will not allow that kind of a question. As I said, the best evidence of that transaction are the documents bearing on that transaction.
Yes, Your Honor, we submit. How much income? May I proceed, Your Honor?
Proceed.
Did Christina Corona pay any income tax in connection with that property transaction?
Your Honor, please, this now borders to the allegation, to the contention of alleged illegally acquired wealth. Your Honor, what is sought to be presented now are the income tax returns, allegedly, of Mrs. Corona, Your Honor. And there is a ruling by this honorable court, Your Honor, that she cannot be examined for or against the husband during the existence of the marriage, Your Honor. So this is proscribed, Your Honor.
Your Honor, counsel, the wife is not testifying here. It is the Commissioner of Internal Revenue. I humbly believe that the rule against a spouse testifying against the other spouse is not applicable in this case. And so that is the ruling of the chair. Now, in the case of this question, lay the premise.
Yes, Your Honor.
Who was the seller and who was the buyer?
The seller of the property.
No, please. I'm asking the counsel to propound the question.
Yes,
because he's not laying the basis of his question.
Yes, Your Honor. You referred to a sale, property transaction in 2003. What transaction was that exactly?
It's a sale of a property in La Vista from Mr. Victor H. Bongkaling to Christina R. Corona.
And
how do you know that, Madam Commissioner?
Sir,
were you present in that transaction?
Sir, I have the certificate authorizing registration that the Bureau of Internal Revenue issues when the...
Then that will become a hearsay evidence. It's not within your actual knowledge.
Sir,
so, counsel, lay the basis.
May we beg for reconsideration? This
Why?
Is, yes, Your Honor. May I proceed, Your Honor?
Proceed.
Please? You stated that Christina Corona registered with the BIR as a one-time taxpayer in connection with that property transaction, sale from Victor Bukaling to the Corona spouses of La Vista property. What documents were filed with your office in connection with that application for registration as a one-time taxpayer, or what you call ONET, O-N-E-T-T? If any were filed.
There is a return that are filed by the parties to the transaction, paying for the capital gains tax and documentized stamp tax for the sale of properties.
Do you have that return?
Yes.
Sir, I don't have the return because the subpoena only said I bring the certificate authorizing registration.
What is this? May I proceed, Your Honor?
Proceed.
What is this certificate authorizing registration that you are mentioning in connection with this transaction?
when somebody sells a property before the title can be transferred, taxes thereon has to be fully paid. And BIR will do an investigation, and when it is satisfied, it will issue a certificate authorizing registration, in effect informing the registry of deeds that they can now transfer the property from the seller to the buyer.
Was a car or certificate authorizing registration issued for that property transaction?
Yes, sir.
Do you have that with you right now, Madam Witness?
Yes, sir.
Can you kindly produce it?
Here, sir.
Witness handing to counsel a document which unfortunately was not all marked our documents because we started 10 o'clock, Your Honor, but we were here 8 o'clock in the morning, Your Honor.
You marked it.
Yes, Your Honor. Witness handed to counsel, Your Honor, a document under the letterhead of the Bureau of Internal...
Will you kindly use the microphone, please?
Thank you, Your Honor. Witness handed... Witness handed to counsel, Your Honor, a one-page document under the caption of the Bureau of Internal Revenue, or which is a form of the BIR form number 1954, revised July 1999, CAR 2003-00.